Hello and welcome, everybody. As I just told the speakers, we are a Swiss-hosted event today, so we start sharp at 3 o'clock or 3 o'clock and 1 minute. Welcome to you all to today's workshop on artificial intelligence and intellectual property law. The workshop is hosted by CIPCO, the Center for Intellectual Property and Competition Law at Zurich University, in cooperation with the Swiss Intellectual Property Institute. And we are, of course, very grateful for the support by the Swiss IP Authority. As you may have gathered from the program of the CIPCO website, today's event is the kickoff for a research project on AI and IP and a corresponding workshop series. 2 more online workshops in September and early in 2022 will assess in detail important facets of the topic, thereby leading up to an on-site workshop with the Intellectual Property Office in summer 2022. At this final workshop, we are going to review what we have learned from the online workshops and consider policy, administrative, and legislative steps going forward. We have an afternoon full of most interesting content before us, which is why I'm going to cut myself as short as possible. To those logged in today, there is no need to explain why AI and IP is a fascinating topic. Florent Thouvenin, Professor for Information Communication Law at Zurich University, member of CIPCO and my esteemed co-host for today, is going to introduce our first flight of speakers in a couple of minutes. But I would like to make an admin remark, so kind of start out with the boring stuff to get to the more interesting stuff later on. As to admin, we will hear from Ryan Abbott, Beat Weibel, and Peter Thompson first, then have a very short break. Then we have the presentations by Kate Gaudry and Daryl Lim. After these keynotes, there will be ample time for questions and discussion. In this Q&A session, we will have very short interventions by Hans-Uli Stamm, Florent Thouvenin, and Begonia González Otero from the Max Planck Institute's research group on AI and IP. But there will be also much room for questions from the audience. Best would be if you flag in the Zoom chat then that you have a question, and I'll give the word to you. If your microphone is not working or you are encountering other technical problems, I can also read out your question to the speakers, but this should be only a fallback option. With this, I already conclude and give the word to Felix Ador, the Deputy Director General and Head of Legal and International Affairs at the Swiss Intellectual Property Institute. Felix, thanks again for the IPI support of this project, and thank you for even being with us in person today.
Thank you very much, Peter, for the very nice introduction. It's a pleasure to welcome you to this online workshop on IP law framework for AI, also from my side. Thank you all for being here. I hope you all are safe and well. Did you know that the most widely used fundamental algorithm in history actually is Swiss-made? It is the so-called LSTM, which means the long short-term memory, and it is developed by the Dalla Molle Institute for Artificial Intelligence Research in Lugano, Switzerland. This algorithm is the foundation of many famous services based on deep learning, developed by the biggest tech companies in the world and leading startups in the field of AI. Since the development of its very first version in the early 1990s and still today, this fundamental algorithm has been accessible, free of charge, to everyone. This highlights that Switzerland indeed is home to world-renowned universities and research institutes in the area of artificial intelligence. And Switzerland is also known for having the highest number of artificial intelligence companies per capita in Europe. Tech giants such as Google, IBM, Microsoft, they all run their AI research from Switzerland in Europe. Given the cutting-edge research and innovation ecosystem in the country, we, as the Intellectual Property Office in Switzerland, feel responsible for ensuring an adequate intellectual property framework in Switzerland and to contribute to achieving such a framework abroad. It was around 2016, the performance of the Swiss AI ecosystem and international developments in the field of AI gave us the idea of founding a so-called lookout group, a team composed of employees from all divisions of our office. Hans-Uli Stamm was one member of the lookout group. Their task was to identify technological and societal innovations that might influence the way IP offices work and that might influence the way the IP system is working. At that time, the topic of AI and IP was not discussed very much, at least not in Switzerland. So it became clear that we would also like to bring it to an interested audience outside of our institute. And that is why we invited Peter Picht to present the topic as a speaker at our permanent series of events called IP at 6 in Bern in November 2018. In those marvelous pre-pandemic days, the experts used to be invited to dinner after their presentation. It was on this occasion, and Peter, I remember very well, it was precisely at the time when the tiramisu was served that the idea of this workshop series was born, and the tiramisu was eaten. Several meetings and some postponements due to the coronavirus later, I'm happy that we can start this series together with Peter Picht and the Center for Intellectual Property and Competition Law at the University of Zurich. Whenever we, the IPI, cooperate with universities, the aim is to make the knowledge generated in academia useful in policy making and to make it available for all our stakeholders. A good example is the collaboration which a group led by Florent Duvenin, which has conducted a statistical analysis of our trademark decisions on opposition and allows to study the consistency or evolution of our decisions. Thanks to the collaboration of lawyers, data analysts, economists, programmers, and practitioners, they have produced both interesting and useful results. These will be published in one of the next editions of GRUR International. To come back to our workshop series of today, our objective is to hear from you, academics and practitioners from different fields and different countries. We want to provide a platform for discussions. The exchange of ideas and the network built will enable us to advise the Swiss legislator with the necessary expertise. Furthermore, we will actively contribute to the work in international fora. So I thank you all for participating, and I thank especially Peter Picht and his team for organizing the whole series. Peter, the floor is yours again.
Okay, thank you very much. Peter, if you allow, I would take over directly as discussed earlier on. Thank you very much, Felix. Thank you very much, Peter, for organizing this event and for having me as a co-host. I would not spend a lot of words on, introductory remarks either. And I would like, as opposed to what you have just mentioned, Felix, I would not like to start with a dessert, but with a starter in, the regular order of having dinner with the first talk given by Ryan Abbott. Ryan Abbott is a professor of law and health sciences at the University of Surrey School of Law and adjunct assistant professor of medicine at the David Geffen School of Medicine at UCLA, so in Los Angeles. And he's also a licensed physician, a patent attorney, and an acupuncturist in the United States, and a solicitor advocate in England and Wales. So you see, Ryan is actually having various hats, and he brings all of this experience to the table today. He's also the author of The Reasonable Robot, Artificial Intelligence and the Law, which has been published just last year, so very recently. Have a close look and taking into consideration all of these capacities. I think Ryan is the absolutely perfect fit to kick off today's event with a starter that will provide us with an overview of AI and IP legal issues. Ryan, thank you very much for being here. The floor is yours.
Thank you very much, Florent, for that overly generous introduction. Everyone can see and hear all right? And I am glad to frequently be referred to as a starter because I feel that that sets the bar very low. Everyone is basically waiting for drinks and dessert, and I just have to keep you entertained enough to get to the next speaker. So with that, let me give a little bit of background to what is going on in this field, and then I will talk about a couple of issues of particular interest to me in a little bit more detail. But for those of us with an interest in AI and IP, now is a good time to be in the market because some very exciting things are happening, and they are driven in large part by advances in technology. For example, this is a screenshot from the OpenAI Jukebox initiative. If my talk gets boring and you're looking to multitask, if you go to their website, you can hear that they have had an AI that has trained on the music of various artists and has thus recreated the music of various artists. So you can listen to new music by AI Frank Sinatra, AI Elvis Presley. And it's not that great, but it also isn't as bad as it used to be anymore. Indeed, AI making music is not a new thing. People have been doing it since at least the 1950s. And as I'll get to, it has been rejected by the Copyright Office of the United States since probably the 1960s. But whereas previously you would only listen to AI music as a novelty and then probably not again, it's now getting to the point where it's kind of okay to have on in the background. And it sounds something like something Katy Perry would make. And I think that's going to be interesting and disruptive to intellectual property law and society more generally for a couple of reasons. One of which is that once AI gets to this stage, it can make more music at almost no additional cost. So whereas there is quite a substantial cost in having people make music, all you have to do is get an AI to the stage where it can make this music and it can churn out an almost unlimited amount of it at no marginal cost. And second, it's still getting better. So in 3 more years, 5 more years, 10 more years, Katy Perry may have a hard time competing with Katy Perry AI. And again, we can't all be Katy Perry. Mm-hmm. It's not just music that AI is making. It is being used by media outlets like the Washington Post and Tencent to write short articles. It can write short articles in ways that people generally can't tell they were written by an AI. It is making artwork and paintings, which are selling at least sometimes for not insubstantial amounts of money. And there are even gallery exhibitions devoted to AI art. And it is making new scientific sorts of advancements, although that is a loaded term. But last November, for example, DeepMind, which is owned by the company Alphabet that owns Google, this is the same company that had developed an AI that beat the world champion of the board game Go, announced that their AI had dramatically outcompeted human and AI augmented teams in a long-standing annual scientific challenge. And the challenge is taking a 2-dimensional protein sequence and predicting what it will look like in 3 dimensions. And this is interesting for a couple of reasons. Again, the Go victory was a big deal because that was a machine outcompeting a person at the last board game that we could outcompete machines at. So AI can now dramatically outcompete a person at every traditional board game. And traditional board games have long been a measure of machine intelligence, but there's not too much practical value in winning a game of Go. By contrast, predicting protein folding sequence can be a critical aspect of drug discovery. And so this is an AI advance where an AI is outperforming people and doing so in a way that has the potential to contribute to research and development. And that is, again, interesting for a whole variety of industrial and social reasons. But from an intellectual property perspective, because predicting protein folding sequence might be the key to a new patentable invention. And if November is too far in the past for you, it hardly seems like a week goes by without some new exciting thing that it turns out artificial intelligence can do. This paper came out this Wednesday from Google and talks about how an AI is being used through, well, I forget the particular AI technique it used, deep reinforcement learning, to design chip floor plans, which is an engineering task associated with designing computer chips. And they say that what would have taken a team of people months can be done by the AI in 6 hours, and that it outperforms human designers. And this is interesting in part, again, for a number of reasons, or I guess I just find things interesting for a number of reasons. Everything won't be interesting for a number of reasons. We'll get to single interesting reasons soon. But this, again, is an AI contributing to an AI's hardware design. So it is an AI essentially being used to improve AI generally. But again, this is the sort of thing that is also the subject of patent applications, or in the US, perhaps sui generis chip protections, or perhaps some sorts of design patents. But it is, again, AI generating new traditionally protectable intellectual property, and again, in ways that may outperform what people are able to do. All of these technological advances have not gone unnoticed by regulators and policymakers. And again, it is not really that AI is doing so much that is new. It is that AI is getting better at doing these sorts of things. In fact, in my research, the earliest reported case study I can find of people saying that an AI invented something that came up with a patent was from the 1980s at Stanford. And it was, in fact, an AI which used a more traditional expert-based system doing chip design just like that. So AI may have been doing that for a solid 40 years, but it's now getting good enough that Google is publishing about it in Nature. The US Patent and Trademark Office in August of 2019, which is now almost 2 years ago, announced a request for comments on patenting artificial intelligence inventions, and then a request for comments on other issues in intellectual property and AI. You know, part of the debate about this has indeed been around terminology. Artificial intelligence and inventions isn't a term that's used so much anymore, but part of this discussion is indeed refining the terms we're using. And this was a fairly broad comment on how advances in artificial intelligence were going to impact different areas of intellectual property law. So it looked at things like patents and copyrights and trade secrets and trademarks, IP and AI and IP administration, so how AI is being used by patent offices. And it also talked about all sorts of issues raised by this, such as ethical considerations around the use of AI and IP, for instance, with relation to deep fakes, you know, competition law challenges associated with this, privacy issues associated with this. They received a very substantial number of submissions, all of which are publicly available on the USPTO website, and published a report in early 2020. Not to be left behind by the United States, the UK Intellectual Property Office also recently announced toward the end of last year a request for views on AI and IP. Again, this fell into similar buckets of sorts of requests and issues. It received a very substantial number of responses, and the UK IPO has now posted all of these responses online together with a summary of them as a start to additional discussions among stakeholders and policy makers about how best to accommodate these sorts of advances. Aside from patent offices, there have been quite a few studies, investigations, and reports done in recent years. This is one from March or April of this year, and it was by the National Security Commission on Artificial Intelligence. It was chaired by Eric Schmidt, formerly at Google. And this was a fairly high-level report coming out of the US government. It is a 750-page report, and I had asked Peter if I could go through this and summarize it page by page, but I was told in Switzerland, you keep your conferences to time, and so I am not going to do that. I'm just going to give you the high levels. This, as the name might suggest, did have a kind of key national security focus on it. So it was in part about national security and military readiness. And the gist of the study was surprisingly, as quoted here, AI is not prepared to defend or compete in the AI era. It is a tough reality, but we're going to have a grand national plan for this sort of thing. And this report does focus a great deal on China and very much buys into the idea of an AI arms race between the US and China, one which the commission authors think that the US is not doing that great at. And if the US doesn't step up to this, that they're going to lose. Probably someone from that committee is attending today and will have heard Felix's comment on the Swiss. So I think there will be a version 2, perhaps focused on the strategic AI threat posed by Switzerland and LSTM. But this one at least is focused on China. That, and if my academic overlords ever heard that my research was supposed to be of practical value, I think they'd have to reevaluate my contract. Peter did say we were supposed to interact with the prior speakers, so hence those comments, but I'll move on. This report, which is mainly focused on national security issues and on national governments of AI as an industrial matter, does have an entire chapter devoted to intellectual property. So intellectual property, is key to industrial strategy, to national security strategy, to competition strategy internationally. Again, with quite a focus, as you could even see here, in China, but it identifies a number of issues associated with AI and IP that have those sorts of implications. Patent eligibility for whether using an AI will render something patent ineligible, or for computer implemented inventions. Computer implemented inventions, particularly under US jurisprudence like Alice, in the past 10 years have received a lot of attention, but are also the subject right now of kind of ongoing on and off congressional hearings about whether to amend US patent law. China has recently overtaken the US in a number of patent filings, particularly in AI. Some debates about how important that is as a metric, but the report puts a lot of emphasis on China's narrative that they are doing more filings. Looking at greater government investments in these areas, more public-private partnerships, and commercializing intellectual property that comes out of those partnerships. As AI and IP is again kind of raising the existence of issues that existed before, like computer implemented inventions, it has also had a lot to say about data and data protection. So data protection as a database or per se has something else that has gotten a lot of attention over the past decade and has taken on particular importance in the context of AI, because among data's many other values, it has value for training AI, particularly AI that uses machine learning. And so data is having this new and important value, and it raises a number of challenges around that. Like, does this mean that people who generate data for purposes of training AI should get some extra protections associated with that data? Or could you have exceptions to things like copyright infringement for using data to train AI? That is not a use that has traditionally been protected by copyright necessarily, because it has not been a particularly important use. And it's not clear if that's the sort of thing that copyright law is designed to be protecting. There's concerns about IP theft by countries that shall not be named, but are named in fact in the report, about issues about inventorship by AI, which I'll come back to, about global IP alignment efforts, because of course, IP frameworks are sometimes harmonized between countries and sometimes not. And there is a risk in the AI field that a lack of harmonization is going to result in some real perverse incentives. And then about SEP patents in France, and about democratizing innovation and IP ecosystems. Again, this is happening very much on both sides of the Atlantic and elsewhere in the world. These are just the two places I happen to be most. The European Commission in April announced this draft regulation for AI regulations. Yeah, that sounds right. This particular report isn't so terribly focused on AI and IP, although there have been a number of reports kind of commissioned or involved with the European Commission or European Parliament that have been. But this is a particularly interesting draft regulation because it is, perhaps in the future going to be the foundation for a binding set of rules about how we regulate AI, which includes how we regulate AI in the context of IP. And it uses a risk-based approach to suggest that certain uses of AI will just be off limits, like using AI to generate social scores, or using AI in real time by law enforcement agencies to do facial recognition in public spaces. Other sorts of uses will be considered high risk uses and will be subject to significant governance standards. This is sort of similar to the way that, for example, certain medical devices are regulated, but this will include uses of AI in, say, employment decisions. So using AI to select candidates to be hired or to select candidates to be fired would be a high risk use and would be subject to heightened governance standards. And there would be enforcement by member states, but an overarching set of rules around this, how this would have to be done. And then most other uses are low risk, but this would be another regime subject to GDPR plus enforcement penalties. I believe it is up, for violators up to 6% of a company's global revenue, or 30 million euros, whichever is higher. I'd have to check the numbers, but it is an astronomical potentially amount of money for the real bad actors out there. And this would apply to anyone, having AI that touches Europe pretty broadly. And then this has not only been going on at the national level, it has also been going on at the international level. And WIPO has been leading a series of conversations on intellectual property and artificial intelligence. This is a screenshot from the second section, which was held online due to COVID. The first section was held in Geneva, and they've subsequently had a third session. They've also had an interactive AI exhibit on new technologies that I think is still up if you go to the WIPO website. And the WIPO initiative has been a little bit less about proposing concrete policy solutions and a lot more about bringing member states together, about bringing stakeholders together and trying to define the language that we're using to discuss these issues and trying to define the issues that we're working on solving and to propose some efforts for harmonization. One of WIPO's major goals in this area too has been to harmonize and share use of tools like AI used by patent and trademark offices and IP offices. IP offices are facing a substantially increased volume of filings and workload. And in fact, people filing applications can use AI to help with that. For example, there are AI tools like a company called Specifio that makes an application. You can enter a patent claim and it will generate an entire patent application for you. AI can generate trademark filings fairly well. And so trademark offices are also in their own arms race, but this time not between China and the US, between somehow processing the volume of applications they're getting and doing it intelligently. But of course, in doing that, there's risk too. There's risk that IP offices are going to be offloading responsibilities onto machines, which they may not entirely understand how they work. They may not be transparent. There will need to be accountability for this. And even in the more mundane use of an AI as a tool to help examiners, there's lots of questions by examiners about, for example, how AI helps with prior art searches for patents, what it's doing, what it's looking at, what it might not be looking at. WIPO has a new director general, but they also have a new division devoted to AI and IP that is, again, helping a lot with IP or AI and IP administration, but also getting into some of these substantive issues. There are a lot of challenges, again, associated with AI and IP. We touched on a couple of them as we went through some of these reports, but for things like patents and trademarks and copyright, whether you could have infringement involving AI or by AI. So for example, if an AI was practicing a patented method or out on the web using copywritten material, if this wasn't directly at the instigation of a person or a person wasn't directing it, does that still count as intellectual property infringement, and who would be responsible for it and on what basis? Of course, it would be hard to hold an AI liable for copyright infringement. In all different areas, these raise some interesting questions. I'm going to talk about patents in a bit, but even in trademarks, as you have AI that is essentially out shopping for people, does AI have some sort of impact on what it means to be an average consumer? Or if AI is no longer looking at traditional trademarks to help guide purchasing decisions, how does that impact trademark law? Should we have text and data mining exemptions for AI using copywritten material? And so forth. So with a little bit of time left, I wanted to talk about a couple of interesting issues that have come up with AI in the context of patent law, one of which is a test case I'm involved in, which involves a team of international patent attorneys filing for protection on 2 inventions made without a traditional human inventor. This is a PCT filing from this effort. As you can see here, the applicant is listed as Stephen Thaler, and the inventor as Dabbus. The invention was generated by an artificial intelligence. And just to give a brief understanding of how it is that an AI could make something that's patentable. And just before I keep going, Peter, we started a couple minutes early. Am I still good to 6:45, or do you want me to, how long
No,
do
that's
I have
perfect. Just go ahead. It's so interesting. Go ahead.
Thank you. All right. I'm glad you find it interesting too. Everyone else is just going to have to put up with it. But this is a version of Dabbus, or the predecessor to Dabbus, that existed in the 1990s. And essentially you had 2 neural networks at least. One was a neural network that you trained on data. So let's say you could train this on chip designs. You could give it schematics of these are microchip floor beds. And as it sees this data, it alters the connection weights between these artificial neurons. So those are, well, I'm pointing at that and you can't really see that, but these kind of gray lines that you see there are stylized connections between artificial neurons. And as it trains in data, it alters the connection weights, and this essentially stores the data in a neural network. So for example, you could show a neural network that's been trained like this, schematics of chip floors, and it would tell you whether it had seen these things before or not. The machine essentially self-stimulates then, somewhat chaotically, its own network weights, and so this corrupts the data that it's seen. And essentially what this would do would be, it would start outputting some new chip floor plans by essentially taking the data it had already seen, changing it slightly or a lot, and having it start come out. If you then trained a second neural network on what that network had seen, it could tell you if something coming out was new, so it would identify novelty. And if you told it some performance characteristics you wanted in the chips, for example, I want a chip that can use half as much power, it could identify, salience or value or potentially non-obviousness if you trained it to. So this is how a machine like that can work and detect the value of its own input. Dabbus now 25 years later is substantially more sophisticated. It uses thousands of neural networks and millions or billions of artificial neurons, and each network encodes for a conceptual idea. So this may be something like, it can be words, it can be images, it can be audio files. So it could be something like money, bills, yuan, dollars, francs. The machine is trained to combine basic concepts together, like, academics don't make money, or academics lectures are interesting. And then it will be allowed to self-perturb its own networks the way it did earlier, and it will chain basic concepts into more complex ones, and can output combinations of concepts in essentially natural language. So in 2 cases, the person who trained this machine had no background in engineering of either emergency signals or beverage designs, and it came up with a beverage container based on fractal geometry. So this would be essentially a beverage container that looks somewhat like a snail shell that may help with storage and transportation and grip. And it came up with a a flashing light that would attract in a way that would preferentially attract human or AI attention. So if you had a plane crash at night, a light like that might help to signal and attract attention. And in our case, we reported that there wasn't a person who qualified as an inventor on this, because although there was someone who trained the machine, he didn't train it to solve any particular problem. He trained it just from general information, and recognizing the value of the output didn't require any inventive skill. This, again, wasn't the first case to report this, and there have been some high-profile cases since this, but this was the first case that explicitly declared this in filing for a patent application. Indeed, it may well be the case that with this sort of activity, you do have human inventors, because someone finds a problem for the AI to solve, and sometimes finding a problem can make someone a patent inventor, but usually problems are well understood and not what makes someone an inventor. Training a machine on particular data might make someone an inventor also, but again, it would probably have to be someone selecting data to solve a specific problem. If someone didn't even know what problem the machine was being used to solve, that wouldn't traditionally qualify someone to be an inventor. And potentially also being the first person to recognize the value of the machine's output might make someone an inventor. For example, if you had a AI in drug discovery that said, here's 10 possible cures for COVID, go test the right one and see what works. But if you presented a COVID antigen to an AI and the AI said, here's your treatment, here I've pre-formatted it as a patent application, and here's the in silico experiments needed to validate that, it's not clear anyone's exhibited any inventive skill. There hasn't been a lot of law traditionally on this sort of question. There has been more on the copyright front. So the UK was the first country in 1988 to explicitly provide for protection of computer-generated works. And these are works that would otherwise qualify for copyright protection, except there's no person who traditionally qualifies as an author. In a case like that, the producer of the work, like a film producer, is deemed the author, and the work gets a shortened period of protection. It gets 50 years of protection rather than 70 years plus the life of an author, which makes sense because machines never die and they're not alive in the first place. Plus 70 years plus life of the author is really only something Disney would need. The US has gone in the opposite direction, formally since at least 1973, but really since before that. And in the US, an AI generated work cannot be protected by copyright, which means that music by Katy Perry being generated by OpenAI, you should be able to go ahead and use, or the portrait of Edward Bellamy that sold for $500,000 at Christie's a couple of years ago shouldn't have copyright protection. And this is not a statute. This is based on a Copyright Office policy, and they cite to this 1884 case of Burrough Giles v. Cerrone, or 1880 something anyway. This was the case that the Supreme Court, in which the Supreme Court of the US first held that copyrights were eligible for, photographs were eligible for copyright protection. Previously there had been question about what specifically could receive copyright protection, and after this, the Supreme Court said any idea in the mind of an author that is given tangible expression, fixed in a tangible medium, is eligible for protection. So that meant that photographs were potentially eligible for copyright protection. And the Copyright Office has since decided that because machines lack minds, their output can't get protection. Machines and monkeys, this policy was almost tested in the US a few years ago in the monkey selfie case. This was involving a series of images a monkey took of itself. This is not a happy monkey. This is a black-crested macaque in Indonesia, and they bare their teeth as a display of aggression. So this monkey is looking at a reflection of a monkey in a camera lens and not liking it. This is back when cameras had large lenses. But this picture proved very popular. And when the photographer started trying to exert copyright in it, the Copyright Office actually specifically responded, photographs taken by monkeys can't get copyright protection, which seemed to put the issue at rest until PETA, People for the Ethical Treatment of Animals, sued on behalf of the monkey in the Ninth Circuit in California, arguing that the monkey owned the copyright. PETA would help with the lawsuit and split the proceeds. That case was dismissed, but not on the basis of the human authorship requirement by the Copyright Office. It was just dismissed on standing. The Court of Appeals of the Ninth Circuit held that unless Congress is going to make clear that animals have standing to sue, they can't bring lawsuits. And so this policy has not yet been tested in court. The policy of whether an AI-generated invention can receive patent protection has been tested in court, or at least is being tested in court. It has been rejected thus far. Our cases in the US, the UK, in Germany, in Australia, and I think in a couple more places, but all of these are under appeal and in Europe. In the UK, next month, we have a Court of Appeal hearing on whether an invention generated without a traditional human inventor can receive a patent, who or what would be listed as the inventor and who would own the thing. We listed the AI as the inventor in this filing, not to credit the AI, because of course the AI doesn't care about how many patents it has to its name, but to inform the public of the fact this was an AI generated invention and to keep someone from taking credit for work they haven't done. After all, if I could get that Google AI to design 10,000 microchip designs for me and I could be the inventor of all of them, that would change what it means to be an inventor, a human inventor, and I think discredit human ingenuity from people who have legitimately invented. Of course, an AI wouldn't receive a patent. No one's ever suggested that as far as I'm aware. The AI's owner would own the AI's patent the same way the AI's owner would own its output as a trade secret before disclosing it. And the patent system is designed to encourage the disclosure of trade secrets. So it seems particularly perverse that by trying to get a patent on AI output, one would lose any protection they have for it. You know, we also argue that as the patent system is designed primarily to incentivize innovation, this really doesn't change when you have AI generated inventions. Of course, again, an AI doesn't care about getting a patent, but companies like Google do care about getting patents, and companies like Novartis and Siemens care about getting patents. And if an AI is going to be the best way to generate a new chip design, a new cure for COVID, or a new component to a car, we see no reason that sort of thing shouldn't receive the same level of protection. In the US, we just had a district court hearing on this. And in Europe, there is a Board of Appeal hearing set for December. The president of EPO has recently asked to intervene in this case, and the board has asked him to address whether or not having a human inventor is a necessary part of having a patent application, and also whether the European Patent Office has a mandate to investigate this issue, because under the European Patent Convention, issues of inventorship are really left to member states, and never has inventorship been a substantive bar to getting a patent. With just a couple minutes left, I just want to touch on one of the other interesting areas that AI is going to impact IP and patents, which is the person having ordinary skill in the art. If the person having ordinary skill in the art is essentially an average researcher, and average researchers these days are using AI, that seems like it makes average researchers a little more sophisticated. It makes them more knowledgeable, it gives them new problem-solving techniques, and it seems to raise the bar for coming up with an invention, or for setting the threshold for being an average worker. And as I'm going to be Swiss and keep to time, I'll just say that as average researchers use increasingly sophisticated AI to the point where inventive AI really becomes something that average researchers use, that may set a whole new threshold for a person having skill in the art. A person having skill in the art may be someone who can use an inventive AI like something from DeepMind, or actually that really the inventive AI just represents the standard. And as inventive AI gets better, the same way that Katy Perry music making AI gets better, it's hard to see where the limit on how sophisticated an average researcher could become, and thus the bar to patentability may just keep rising. I will end there, and thank you so much for your time and attention.
Thank you so much, Ryan, for this great overview, the great first starter. We will move on to the second starter, which will be kind of a fusion of Swiss and German cuisine. Unfortunately, neither Switzerland nor Germany, in my perspective, are very famous for their cuisine. Nevertheless, I'm looking very much forward to receiving the talk of Beat Weibel. He is the Chief IP Counsel and Group Senior Vice President at Siemens in Munich, Bavaria. And he heads Germany's largest corporate department for IP rights with more than 400 employees worldwide. In addition, he's also a member of the board of Ingress, the largest association of Swiss IP professionals. And thanks to this engagement, I have the pleasure to meet and exchange with Beat on a regular basis. And as always, I'm very much looking forward to hear his thoughts today on the business perspective on AI and IP. Beat, the floor is yours.
Thank you very much, Florent, for this kind introduction. And I try to share my screen. I hope you can see my slides now. Can you? Even in presentation mode now?
Not yet.
Not yet. Giving another try now.
Yes.
Very good. So it's my pleasure to talk about the digital inventions and in particular AI inventions from a manufacturing and infrastructure perspective. I would like to do this a little bit in a broader framework and scheme because for me, AI is only one. It's maybe the fastest and most important element of the digital revolution we are in. And therefore, I would like to put it a little bit in a broader framework and finally draw some conclusions about changes we need for a modern IP system meeting the challenges that digitalization and AI creates. So for Siemens, AI is everywhere, digitalization is everywhere. We are in the midst of one of the most substantial transformations of industry. And this is one that in particular occurs extremely fast. Technologies and offerings change from mechanical over electrical to digital to artificially intelligent. And this is true for all our businesses, for energy you see on the screen, for transportation, healthcare, and manufacturing. And to start with, and I hope that will also work, I would like to share a shortened video with you. And please particularly pay attention to the last sequence about the sports car.
Digital twins, the innovation backbone of the future.
Can you see that?
Delivering virtual representations of real-world products, systems, and cities. For example, the digital twin of an electric motor not only showcases form, but also analyzes functions, from the rotation of the shaft to thermal conductivity to data from sensors and beyond. What's more, the digital twin continuously evolves, thanks to the flow of data, user experience feedback, and new input, and it's greatly impacting development, production, and operation. But this is just the beginning, and Siemens is already driving the future. Merging digital twins with artificial intelligence allows computers to independently design advanced products. Siemens is realizing this potential right now with Californian startup Hackrod, which aims to build customized sports cars.
Good, so that was the video. Now I have to switch that somehow back and go back to the slides. This digital transformation is only one part, but as a matter of fact, we are more and more living in a digital and interconnected world. No company is able to master all these different technologies and developments. Rather, companies concentrate on their strengths and competencies and interconnect with other players to achieve their business goals. My company, Siemens, is a good example, whereas we have been a huge conglomerate until a few months ago. Siemens transformed into a group of 4 independently managed companies, Siemens AG, the company, the mother company that I'm working for, Siemens Healthineers, Siemens Energy, and Siemens Mobility. All of these group companies focus on their specific strength and hopefully have not too many weaknesses. Also, the extremely successful hyperscalers like Amazon, Google, Apple have created entire ecosystems based on their platforms. And without third parties offering their services and products over Amazon, for example, or developing apps for Android, Amazon, and Google, these companies would not be as successful as they are. So success today is all about collaboration on the one hand and differentiation on the other. To shed some more light what digitalization means for a company like Siemens, I would like to share this scheme with you. What you see here is, let's say, a traditional approach of manufacturing electrical motors in a factory that are used in an elevator. Traditionally, in a shop floor, even with robots or other machines, these robots and machines were driven by local OT, operational technology. And eventually these systems were interconnected with an enterprise IT system like SAP. Delivery and application, for example, in the elevator, were not connected in the same way as the power supply here in the scheme was not connected. With the introduction of Internet of Things platforms, it was possible to interconnect everything from production over delivery to use, including power supply, and to build a closed loop ecosystem. It was even more possible to connect that to the SAP system. And finally, to create an open ecosystem with proprietary and open applications for running, analyzing, optimizing, and controlling the whole system. Why do I explain that? Because from an IP point of view, this particularly means new business opportunities were created for this consulting, implementing, operating the IT services. New business opportunities also means new competitors for Siemens, of companies like Microsoft, Amazon, Google, Accenture, Tata Consulting, you name them. The system must be open in order to be successful, and in order to share the profits of the contributions, the IP or the contributions that are brought in such a system must be clearly defined. So therefore, in such a system, as you can understand, intellectual property plays a major role. This is true also for the famous sharing economy, because in my view, you can only share something if you own something. And owning something means you must define the ownership of an intellectual achievement. And you must define who owns it and to which extent he or she owns it. And this is done by IP rights. And that's what, in my view, IP rights have become much more popular in the meantime, to define one's contribution to a digital ecosystem, because they not only define who owns an intellectual contribution, but also to what extent he or she owns it. So that's a little bit the framework we are acting in as a company. And now, as you have seen in the movie, in a digital world, inventions are harder and harder to protect by patents, as we have learned by the recently decided decision of the enlarged board of the appeal of the European Patent Office about simulation patents. And all these digital twins that you have seen in the movie are actually simulation inventions. Therefore, if these simulation patents wouldn't have been allowed, that would have really affected our business. Why is patenting so important? That I would like to explain with you in the next slide, because copyright is just not enough for software inventions, and all these simulations patents and also the AI patents are at the bottom software patents. Copyright, as you can see in this slide, is only useful for creating software in the coding phase, whereas patents can be used in all phases of the development processes. And of course, this protection can be optimized by design rights and by keeping certain things secrets. And this is even more true for AI inventions. As we already have heard from Ryan, there are different types of AI inventions. I just want to explain that in this slide where AI inventions can be created. For example, in the training data, how training data are employed to generate a neural network suitable for a specific task. Or in the algorithms, for example, the type of algorithms that is needed to run a network. But also in the post-processing or pre-processing of data, which is very important, and in the whole workflow. But this can all be managed because, as I said, at the end, these are computer implemented inventions. It's just a specific type of computer implemented inventions. It's maybe more complicated, but is still a traditional computer implemented invention. The real problem exists, as we already have heard, with inventions created by an AI system. And what you see here is now a suspension of this sports car that was shown in the movie. So the problem is not with AI inventions or inventions about in AI themselves, but with inventions created by an AI process. And if you compare the two pictures, you will see there is a difference here in the direct mechanical linkage between these two eyes. So we can take it as granted that this is a novel design. And if it is also inventive, there shouldn't be any reason to not protect this AI created invention by patents. But we lack a human inventor for this AI created suspension. And therefore, it would be excluded from patentability. So we need a solution to this problem. And in contrast to the Darbus approach, I would not go for naming the machine or the AI system as an inventor, but try to expand the term of inventor to legal persons that control this AI process. So in the same way as under the American Invents Act, not only the inventor is entitled to file a patent application, but now also applicants or employers are entitled. We could expand the term inventor to legal person that control the process of the AI system. In my view, this would be the much better approach, an honest approach, than to name a natural person or a machine for such an invention. So to sum up, I would like to state some requests what we need for a modern IP system. Since we are living in a digital world where ecosystems are becoming more and more important, we need a measure to protect one's contribution to this digital ecosystem. Digital ecosystems can be compared with a bring your own party. In the long run, you are only a welcome guest if everybody appropriately contributes. Free riders are not welcome and will not be invited sooner or later. This works only if the contributions of the parties are respected. To this end, they have to be clear in scope and ownership and documented. And in order to meet the challenges of digitalizations, we need patent protection for simulation inventions. I think here we have made a step forward. I request that we expand the inventor to legal persons for AI inventions where now no natural person has creatively contributed. And I suggest to the representatives of the IP to seriously consider that, because the Swiss Patent Office could be a front runner in this respect. We also need flexible examination terms because not all inventions have the same product cycle. And I also suggest that we create a EU software register to allow easy registration of copyrighted software. This is a little bit the cliffhanger for the question session, because we, on the one hand, we need a balance to countermeasure for the ever increasing number of patent filings. But the other reason that why we should have such a restriction, I would reserve to the question and answer session. Thank you very much. And at the end, you can see my personal private Van Gogh picture created by a AI system. Thank you very much for your attention.
Thank you very much, Beat. I'm very much looking forward to the discussion, and I'm also happy that you have 2 ears on that Van Gogh picture. Very comforting. So without any further ado, I would like to move on to the third speaker. The last one before we'll have a quick break. I'm very much looking forward to listen to Peter Thompson. He's the manager of global IP and litigation and also transactions at Novartis International in Basel, Switzerland. So again, Swiss cuisine, maybe a Basel Leckerli or anything like that we will get in just a minute. Peter is also a member of the board of VIPS, the Association of In-House Patent Attorneys in Switzerland. He is very well known in Switzerland for providing insightful thoughts. We're all very much looking forward to your talk. Peter, please, the floor is yours.
Yeah, thank you. I hope you can see my slides in presentation mode.
Not in presentation mode.
Okay.
Yep. You probably have to switch the screens, exactly.
Swap. Maybe.
Yes.
No. Okay.
Thank you.
Good. Yeah. Thanks for giving me the opportunity here to present a little bit the artificial intelligence and IP from the perspective of the pharmaceutical sector. Generally, and this is a very quickly moving field, as we all have now heard also from Ryan Abbott and also from Beat Weibel. And the pharmaceutical industry, you have to understand, is not necessarily on the forefront of it. It's rather a follower in this whole developments, but you have to see also during the last, I would say, 3-4 years, it has become a very dynamic developments also in the pharmaceutical sector with regard to artificial intelligence. And I will try to give you a little glimpse on the questions, the issues there. First of all, let's remember what the core business of the pharmaceutical classical sector is. It is to come up with new treatments, usually new drugs. And those are usually either chemical or biological in nature. And as you may all know, I mean, this takes quite a lot of time from the first research into that new compounds until a new drug is brought to the patients in the market after also a detailed regulatory review by authorities with a lot of clinical trials, with a lot of patients, volunteers. You see there are the numbers. Usually you start with a few tens of volunteers, then you go in the phase 2 with 100 to 500, and then finally in the phase 3 with thousands of patients. And then you submit your clinical trial results to the health authorities, and hopefully then after a review period, you get your marketing approval, and then you have a drug out there, always here based on the assumption with a new active ingredient. Later on, there may be also new indications of drugs with known active ingredients. That goes usually a little quicker than that, but also still needs years to come up. Now, this is the traditional way, and artificial intelligence can play now a role in each of the phases of this development, research and development process. For instance, in early research. In early research, you may have prediction models for new molecules, trying to predict the toxicity of molecules. There have been algorithms developed under research projects, and yeah, they're not so bad. You can rely on that. If you check it later on, they have accuracy of 70–80%. You can have in silico design, where you have in the computer, you are testing your molecule. I was reminded a little bit by Beat Weibel's example of the twin, the digital twin. You may have your digital twin as a molecule and try to test it in silico, whether it would fit to a certain biological pathway, to a certain enzyme, or whether it would block it or not. But this is, at the moment where we are today, this is only a good guess, a prediction, which still has to be confirmed in the lab finally. Then you have the late research and development, the clinical trials. We will look a little bit more into examples where artificial intelligence can play a role there. That is, from my point of view, at the moment, the area where the artificial intelligence is mostly used to reduce the time and effort in the clinical trials. After you have your product on the market, or even before that, you need to think about manufacturing capacity, manufacturing processes. You also can use AI there to best allocate the resources for your manufacturing. And even in marketing, artificial intelligence can play a role. I mean, you may have a software for your field force telling them where it is best, where their time is best invested, which doctors to visit, with which topics, at which time. Based on the right training data, this could create higher efficacy of your field force, which also increases the overall efficacy. And then we are going into the post-market surveillance. Once a drug is on the market, you still need to collect all the potential side effects, the observations from doctors, from clinics. And this is then in what we call the real-world data or real-world evidence. And that is also something where artificial intelligence can play a specific role in better using them. We will see an example in a few minutes. And finally, I would like also to make you aware, I mean, this has already been mentioned a little bit, touched a little bit by Ryan Abbott, of course. The artificial intelligence may also be suited to be used for the IP function, for the functioning of the IP function, the internal IP function itself of a big company, and that is not so specific for pharmaceutical sector. I would say this is more of general nature. Now let's have a look at some examples here. Artificial intelligence to improve the clinical trials. You see here the two big areas within the clinical trials where artificial intelligence already today plays an important role. One is in the trial design. Artificial intelligence can help to reduce or to improve, to increase the chances of success of clinical trials by defining the right endpoints. The endpoints are those criteria you want to measure for a new drug candidate within your patients, and which need to be accepted by the health authorities as evidence that the drug works. And artificial intelligence can really help to find the better endpoints. Of course, you always have to have an agreement with the health authorities finally that they will accept this. And then you can use the artificial intelligence to best make use of the clinical trial resources. So to allocate, to find the right clinical centers where you give out your clinical work to the doctors there or the hospitals, and then to analyze the data which come back from those centers. Also to very quickly analyze for data which are contradictory, which cannot be, where you have to very quickly check back, was there something wrong with the performance of the clinical trial. That can all be facilitated by artificial intelligence. And then, of course, in the data analysis, the data results. But then we have another class of artificial intelligence which can help to improve clinical trials and to make them shorter from a time and a resource perspective, to have it with maybe less patients and still come to the same statistically safe results. And this is if you combine your clinical trials with sensors. And there's a huge opportunity now provided by all the variables or the biosensors, which can so easily be weighed by patients during the clinical trials. And you can collect much more real data during the clinical trials than you could do this whenever the patients had to visit a clinical center, and then the doctor or the nurse takes a blood sample, and then you can only punctually check certain data. Here you can have it real time, basically. And as one example for this latest class of use of artificial intelligence in the pharmaceutical industry, I show here the example, which is one of the first examples. It's relatively old. It comes from around 5 years ago already. And it was a Parkinson trial for Parkinson drug candidates by Roche, and they developed also a smartphone app to monitor the patients, because the smartphone is always with the patient. And as you know, you may know, the Parkinson is a disease which causes some tremors, some strange movements of the bodies, of parts of the bodies. And the smartphone, with all this built-in sensors, is very well equipped to realize that and to measure that. So this was used in clinical trials to measure the effectiveness of the drug candidates. Now we go on to another class of artificial intelligence, which is going into a different dimension, I would say. I mean, leaving the clinical trials, there can be even products, pharmaceutical products, prescription products, which are not drug products, classical drug products, but which are purely digital, or I would say more likely, which are combined with drug products, with physical drug products. And one of the first digital prescription therapeutics approved by US FDA was this Reset app by Peer Therapeutics. And this is basically a mobile app which the patients can use who have problems or to treat substance abuse problems. And this app needs to be prescribed by a doctor. This is an for prescription only application. And then it usually runs for, I think, 90 days is one treatment, and is also reimbursed by health insurances. It was approved in 2018 and provides this cognitive behavioral therapy. There is another version of it which is particularly suited to prevent people who are taking opioids, like OxyContin, for instance, heavy painkillers, and who observe the patients who are on painkillers, that they do not get into an addiction. So that is a more combination digital product, helping that a drug becomes safer. Also, you can think of combined digital products which increase the compliance of patients, so that they really comply with the treatment to improve the final outcome. And then we go into another dimension where artificial intelligence is used in the pharmaceutical industry, that is just to try identify new medical knowledge by a better analysis, by deep learning and data mining. But in order to do that, you need all the data. You need access to all the data. And this is now in Novartis. I took as an example the Novartis Data 42 initiative, where internally within Novartis there are huge data lakes are created, by all the R&D data which is available, and this is was half a year ago, 20 petabytes, an incredible amount, plus all the data of 2,500 clinical studies. So it's a huge amount of data. The challenge, it is relatively easy to bring the data together, but the challenge is really to bring them together in a format that you can analyze them, because you need to agree on certain standards. They need to be of similar quality. And that is the big work that needs to first to be invested into those data before you can really derive successfully some useful information out of it, and hopefully to get some new scientific insights out of analysis of those data. And for that you need algorithms, and you may need new algorithms. You may also rely on known algorithms, but you need them in order to find that. And then, yeah, in the post-launch time of a drug, you have the possibility now, what you also already can do during clinical trials, but you can do it easier and much broader if a drug is used by a broad group of populations. You can collect real-world data with the wearables. I mean, every smartwatch can today collect certain data. They are not of good quality, actually. And so here the challenge is also to improve the data quality. And that is what is called from real-world data to real-world evidence. Real-world evidence is at a quality level that is accepted by health authorities, whereas real-world data are more the raw data you are collecting. And there you need also algorithms and knowledge how to clean the data and how to curate the data. And this is a very recent announcement, just a few weeks ago, of a new consortium of companies which would like to go into that direction. And yeah, those are usually not the big pharmaceutical companies. Also, they have partnerships with some of them. Here you see Aetion, Flatiron Health, IQVIA, Synapse, and Tempus. So there are new players on the market. And now, yeah, the big challenges out of this artificial intelligence also keeping in mind intellectual property perspective. Yeah, the business model of the pharmaceutical industry, is it sustainable in a digital world? We touched this already by the previous speakers. If, for instance, at one point in time, a new drug is invented by a machine, purely in silico. And there is maybe no patent protection anymore. Once such a molecule is out, everybody can copy immediately. And that would go totally against the present business model of the pharmaceutical industry. It would destroy it, actually. So having no protection at all is from an IP side is difficult. And I hope I was pretty clear that to come up with high quality data also requires some investments. Also, collecting the data is at marginal cost. I mean, if you have variables and you just collect the data, that's not the big cost, but to curate the data and to bring them into a format and at a quality level that you can really derive knowledge out of it. That is what is also requires a lot of investment. And yeah, then we come then to the IP protection of the marketed solutions relying on the artificial intelligence. You have this inventorship ownership of, I now call them artificial intelligence facilitated inventions, maybe in the future even artificially made inventions. I don't think we are there at the moment, at least in the pharmaceutical area. There is always a human interface involved, and the final human decision making involved also in testing. And then you have potentially other protections. Beat Weibel mentioned them already, copyright for certain software, regulatory data protection that is quite specific for pharmaceuticals or also for agrochemicals would be available. But this is a type of investment protection for the clinical work, the clinical trials that are done. If clinical trials at one point in the future may be replaced by simulations, just by artificial intelligence, then the justification may also go away, and there may be no protection. We don't know. I mean, at the moment, this protection exists and is also there, is relied on. And then design protection for certain graphical user interfaces, which is less artificial intelligence itself, I would say, but it's also sometimes good to have. Yeah, then the scope of protection of artificial intelligence consists patents. I mean, the sufficient disclosure was already also touched by Beat Weibel. That is a big question mark for the future. Question of infringement, also of freedom to operate. Then the development of new algorithms. Are there enough incentives for those who are developing new algorithms? It's not clear at the moment whether the traditional pharmaceutical industry will be those who invest into that new algorithm, or whether it will be relied on other specialized companies. But there, the protection question is really open at the moment. I think it's mostly trade secret. If the trade secret is not working anymore because of increased transparency, because health authorities may want to have this disclosed, the algorithms, if you really touch on the lives of patients, also patient groups, and we all may prefer that the algorithms are checked or are also disclosed at some point if they really affect our lives. And then finally, yes, this was also mentioned, the access or the protection of the data, of the underlying data, the training data. Of course, for pharmaceuticals, all the data held by the hospitals, the doctors, the patients themselves, the medical data, they could be a huge source for new knowledge, but you would need to find a way how to share them, under which conditions. Yeah, other challenges are, well, pharmaceutical industry, as I started my presentation, is not really at the forefront. So the IT expertise was not there. It's built up now, but it's still not at the same place as with the high-tech companies. And also there are different cultures. And that's quite a clash, because in the pharmaceutical industry, especially with the risk aversion or the risk-taking approach, because in the pharmaceutical industry, you want to be absolutely sure that something is running, that something is correct before you submit it to the health authorities and before you bring something on the market. And in the software industry, my impression has been it's sometimes more was the approach to let's first go to the market and then we correct later some errors, small errors or mistakes. And yeah, this different cultures need to come together and need to agree on a certain way forward. That is more an internal problem going forward. But also it means in new partnerships with high-tech firms. Pharmaceutical industry needs to partner with high-tech firms, with algorithm firms, with data firms, and they come from a different angle, and you need to find the ways of collaboration. Also for the contracts, that's not sometimes very easy. I mean, to agree on the contracts. I mean, for instance, if the pharmaceutical industry provides all the library of its own compounds to a data running company for using their algorithm, can the data company use the gained information to pool it as a training data to make their algorithm better for competitors also, where other pharmaceutical companies may also use this? And then you have, as a final point, this use of AI in IP function. Well, that is not established yet, I have to say. We have mentioned it, internal work allocation. Portfolio management is not so important in the pharmaceutical, that's more in other industry sectors which hire more bigger patent portfolios. And finally, then maybe better identifications of inventions or name creation for trademarks. Yeah, and as just as a finger pointer, as in my end slides, an example, sufficient disclosure of AI inventions from the European Patent Office, an interesting Board of Appeal decision from last year, so it's quite recent, was about a medical device in this case. which was the claiming here a method of determining a certain value, where it is carried out with the aid of an artificial neural network determined by learning. And this patent was found not to be sufficiently disclosed because there was no training data included in the disclosure. And that is something, yeah, to be aware of, maybe also alarming. I mean, how much training data will be sufficient to meet the criteria for sufficient disclosure. And with that example, I would like to close and open the discussion.
Great, thank you very much. I think that was a lot of food for thought, and we all deserve a quick break before having the next 3 presentations, and then quite a bit of time for additional inputs and discussion with all the presentators and all of you attending. So I would suggest we make a break of roughly 10 minutes, a bit more, and we'll be back at 4:40 for the next talk. Thanks a lot. See you in a minute.
Okay, so welcome back after the break. We seem not to have lost too many people, which is excellent. Thank you for having the stamina to listen to us and discuss with us later on this afternoon. Before the break, we had several most interesting presentations and heard about the intense business activity that firms like Google, Siemens, or Novartis unfold in the area of AI, about their hopes and concerns regarding not only this technology and its business prospects, but also regarding the IP protection they might or might not wish or get for AI-related inventions. So it seems appropriate to now listen to somebody who actually takes business clients by the hand and leads them to success in their AI IP related projects. We will now hear from Kate Godry. Kate is a partner at the Washington office of the law firm Kirkpatrick, Townsend and Stockton. And a while ago, she was named a rising star in US IP law. The rising has now become a shining star, I would say, as she is one of the experts I had to search for quite a while to find somebody with her profile and standing. She is one of the relatively few lawyers who actually do intense counseling on AI/IP matters, including portfolio strategies. Today, this is still a rather rare expertise, but Kate has it, and this is why I'm looking forward very much to your presentation, Kate. Please, the floor is yours.
Thank you. Share my screen. Put it in the presentation. Okay. So you see my slides?
Yep, perfect.
Thank you. So I'm happy to talk to you, like was indicated by Peter, about more of the practitioner side and what it's actually like to take these inventions that involve AI from beginning to end. And before we can do that, I think we need to clarify some terminology. So AI and patents, what are we talking about? And I think there's kind of two categories that have been touched on in some of the talks already today. Well, the first category is new inventions that involve AI. So perhaps somebody came up with like a new type of neural network or a new use of an existing model where they maybe put it in a new kind of data flow or a new use of an AI result. So for example, for that last one, because I think this might be a little tricky to understand what I mean, but we've had AI that's been used for a while now trying to help self-driving cars. So what if you took that same technology and you said, well, instead of using it for self-driving cars, and predict what the driver should have done and compare the driver's actual actions to that. And then we'll use that to inform how we want to ensure what kind of insurance policy we're going to offer to the driver, right? So maybe people have come up with that. I'm sure someone's tried it, right? But that's kind of a new type of use for an existing AI result. So that's category one. And then category two, which has also been talked about by Ryan and others today, is new inventions discovered fully or in part based on results generated by an AI. So maybe the humans involved, and like what Peter was saying, right now that's almost always the case, or maybe closer to the Davis situation, maybe not. And we might see some changes on that as time goes on, but that has been a rather hot topic that patent offices and stakeholders have been thinking about. So let's start with inventions that involve AI. So this is not necessarily when the AI is contributing to the invention, but AI is more the technology that's at the heart of the patent. So taking you from step 1 to step 10, we start with a disclosure call. And so the questions that I might be asking the inventors, what's the problem that's being solved? What's the advantage of the invention? What is the invention? Tell me how this differs from the prior art solutions. And these are questions I ask regardless, right? These are my standard questions that we're going to go over in the disclosure call. But now here are some of the differences. Here are some of the questions that I find myself asking a lot more in the AI context. And one is really drilling down into the details. I need to understand the technical aspects. And a lot of engineers, they're trained to simplify things and to concentrate on the business case, right? They have to be ready to explain why their invention is valuable to the higher ups. And so I find it rather common when inventors will tell me about the business case and why their customers love it. And they don't go into details because details can scare some people off. And I'm like, no, we need to do that. We need to jump into the lower levels. And then, how did those specific parts work? Oftentimes I end up asking, should we talk to somebody else? Because the person that came up with the initial project or who is driving the project, right, and deciding where it's going to go and what kind of markets they're going to be looking at, those might not be the coders. And so I need to talk to the person where they said, this is the black box. We needed you to figure out what models did they try, what parameters were important, right? These are all of the details that's really helpful to put in. And like Peter was even saying, in the European case where they said there's no description of the training data, and so you can't get that patent. That's why we need to understand exactly how this data flow is working. And how it might be working in other contexts. What might you be able to sub in and out there, and what scope of protection are we going to try to pursue? So I went over some of these things that we're concentrating on during the call: the model architecture, hyperparameters, training data, pre-processing, post-processing, loss functions, like what's actually going to be important to the model. So these are some common questions that I'm asking. And then it's great if they can tell me what didn't work. I love hearing what didn't work. What was the hang up? What was the model that you tried that failed? And then what was the aha moment where everything started gelling together? Right, so concentrating on the failures, for me, like that really helps show the non-obviousness, and it also helps define the scope of protection that we might want to pursue. More questions. I like data. Data is awesome, right? That helps with everything. It helps with showing how the model is actually working, right? It can help with the written description where you're showing that you did in fact come up with this, and it can help with enablement where if you say this is what I did and here's my data, then somebody else can use that. What metrics might the inventor have been using to show performance, and why are they better? So for example, was the concentration on accuracy, or was it on precision, or was it on reliability, or was it on fairness, right? Or did you come up with some other metric? And so I need to understand what was of value to you when you were using this model, when you were training this model, because that can help us show we're different than the prior art for this reason, because we accomplished this thing that they couldn't, or we're better in this case, and it just helps with the description as well. How long and how much data does it take to train your model? Training data is hard to get. We talked about that, a bit today too. And so if there is a process, a workflow, a neural net, any component here where maybe you don't need to get as much training data, that's your advantage, right? And so drilling down into the training data in terms of what do you need, how are you going to get it, and is your model particularly advantaged with respect to training data, can be really important. And then talking about how robust the model is as compared to the prior art. You have a model where training data is great, and that's the data, those are the metrics that we get. And so you take your training data set and you partition it. You say, I'm going to take this first fraction, I'm going to use that to train the model, and then I'm probably going to have a holdout fraction, and that's what I'm going to use to evaluate the model. But if you can go in a totally different context, right? You've trained the model and you had this initial data set, but now you're taking it over to this other context and you're still having good performance metrics, then that's really a great result. Okay, so that's a disclosure call for inventions that relate to AI. And now moving to ones that are discovered, at least in part, by AI. We need to talk a lot, same kinds of problems, but emphasizing what was the type of solution to be determined and how was that identified? Who came up with that, right? Who were the entities, individual people? Right now it's gonna be people, right? People generally, rare exceptions. I mean, DAB some would say it's an exception, but almost always right now there's a person involved there. So who came up with the problem? Who came up with the solutions? Who was dealing with the complications? Maybe that was the AI. Maybe the AI, learned to overcome these solutions that the human wasn't even aware of. What were the technical features of the problem solution and unexpected results? So some of the same questions, but concentrating more on who, right? And who meaning specific person or computer. And we might be getting into who conceived the AI, who programmed the AI, who interacted with the AI, or going even more forward, who was the one who identified the patentable result? Somebody at this point has to be involved. Even if you have an algorithm like DAB at a novelty detector, you still had to file a patent application. So you still had to say, okay, this detector went off, we're going to file the patent application, right? And it might be a pretty straightforward rule where you say, well, that person still should not be an inventor because all they did was, the AI said file this and then they filed it. So they perhaps shouldn't be an inventor, but these are discussion points. And I think more so, if you're getting into a complicated scenario where the AI was really heavily utilized and people are hesitant to sign that form saying that, you know, I am aware that like in the US, you can face imprisonment if you lie on the form about being an inventor. When it gets murky, keeping track of this is important, especially because different jurisdictions, I think, soon are going to start doing different things. And so having good notes about what particular people did will be able to help you, you know, with filing strategies or just prosecution down the line when you might be in front of different sets of rules. A complication. So suppose that AI might soon be generating these amazing novel, non-obvious results. Can the inventor determine or predict these novel or non-obvious results? Can the inventor of the AI determine or predict these results? And if not, are there any IP protections available? So, you know, if I came up with this great code, if I'm, you know, the Davis inventor, but I can't foresee what it's going to be doing. And then, am I out of luck? Well, Ryan contends, he says, yes, you're out of luck right now. You know, that's what the patent offices are saying. In fact, in the US, they explicitly said, nobody can be the inventor, Stephen Taylor cannot. But is that necessarily the case? I thought about product by process claims in Europe. And I say in Europe because I think it's one of the only jurisdictions where you have a shot maybe of this, like a limited shot. Based on my research, in any case, you have to show that your product is new in order to get these claims. But in Europe, then your product can be not tied to the process when it's dealing with infringement, is my understanding. If anyone wants to talk to me more from Europe about that, I'd be interested. And as far as I'm aware, this type of claim has not been pressed, has not been evaluated in the context of AI, and I think that it might still be pretty shaky. But this is like the best thing that I could think of in terms of trying to protect the results of an AI when you don't have it yet. And so you can try to define it, try to get those claims, and then you're not necessarily saying that somebody has to arrive at that product by using your specific AI. Otherwise, just trade secret. That's all you're going to be able to do. And copyright protection, I suppose, but you're going to end up in a situation where people are holding their models, you know, very close to their chests. Okay, drafting the patent application. What am I thinking about when I'm doing this? Again, technical problem, technical solution. This used to be, you know, just Europe, but the US now it's very much aligned with this way of thinking. General technology focus of the application. Again, I don't want to see business case here. I want to go into the inner workings of the model. Emphasis on unexpected results. That can help a lot with, you know, with non-obvious inventive step and even patent eligibility. And an emphasis of why somebody wouldn't have wanted to do that. Pretty standard types of things. For AI techniques or uses, you could use different types of claims that are pretty standard. You know, method, computer system, Beauregard, means plus functions, maybe product by process. Can you claim the result? You know, we talked about this a little bit already. It's tricky. So you can train the model, and if you can understand what the model is going to be outputting, then you can kind of do that. But the more complex and sophisticated the model gets, you can't, because you don't know what that is, and you don't know how you're going to show the patent office this product, this output is new. And then it's just going to be tied to the model. And if it's a complex model, it's going to be very difficult. You could incorporate learned parameters into your claim too. So you could just kind of babysit the model and watch as it's learning things and try to include that in your claims. This can be particularly helpful if you have an interpretable model so that you can add some meaning in terms of what those values mean. Keep patent drafting, keep the novel technology, again, not the market motivation in mind. And one way to kind of check that you're doing this well is to start using AI tools. And so these are becoming more common in the market where you can input different portions of your patent application. You can input the claims, you can input the whole thing, whatever, and it will predict in the US where it's going to land in terms of art units or classes. And this can be helpful, I find, even for training, because it's a check. If you're going to end up in business methods, then you're probably not emphasizing the right things, and you're going to be having a harder time through prosecution. This graph over here just shows differences in, this is not allowance rate, but the probability that a given action is an allowance instead of a rejection. And you can see how that differs across different areas, right? So the blue line is pretty straight AI. The green line is bioinformatics, the red line is business methods. And so big fluctuations in time, big fluctuations in area. Business methods, not so easy to get patents in the US, the same thing with bioinformatics, but you can use this data, the big data plus the natural language processing techniques to help you learn how to draft your patent application. Prosecution, again, stay focused on this technical problem, technical solution. You can see the common theme. I love interviewing the examiner. It can be very common over here, I think even more so than Europe, because you can understand the sticking points. So for example, we have this very complicated eligibility flowchart that we've had for years here. And there's a lot of different ways where you can say, my claims are patent eligible. There's like 4 different kind of steps in the flowchart. And examiners seem to like this one particular step, and it varies across examiners. So by interviewing the examiner, you can understand what's important, and you can avoid a lot of the paper pushing. You can consider inventor declarations. And so if your model is being used in new contexts since the filings, you can use these declarations to submit that data afterwards. Now, you can't introduce new subject matter, but you can use it to show like superiority over art that is cited. And I like to include inventors in examiner interviews if they're willing to do it. They can explain things well, and examiners like seeing their excitement. And then you can use big data. So once you're assigned to an examiner, you can look at his history, his or her history, to see how prone he or she is to allowing a case. And then that might change how aggressive you want to be in terms of amendment strategies and such. All right, so in conclusion, like I said, a common theme was emphasis on the technical aspects. And then it's really important to do this from ground zero. At that disclosure call, you need to be talking to the right person, because otherwise you've started off on the wrong path and it's extremely difficult to fix it. Involving multiple parties, don't be afraid, like at the very beginning, to say, this is great, thank you for contributing your thoughts on this invention, but maybe we should get somebody else involved. Write a lot of notes down at the beginning, because I think this area might be changing in different contexts, like with inventorships, and so it's going to be particularly helpful, I think, to keep good records and then use technology. Right? Everyone here knows how great AI is. Let's use it to help with our jobs as well.
Thank you so much, Kate. That was most interesting. I think we saw from your hands-on checklist on how to counsel clients on filing AI patents, we saw some of the underlying chances and difficulties in the area. I mean, including the move towards trade secrets, because maybe no other a valid IP protection is available. And I also found it most interesting to hear that you actually feed AIs with your draft applications to see how they would evaluate them and use the result for improving those drafts. We will have Hans-Uli Stamm from the Swiss IP office later on, and maybe he'll say a word on whether this is being done already at the office. So this is really, yeah, that was a new perspective. Yet another one after the business and academia perspective we already had. So the table is already quite full with learnings, and I think we need now somebody who helps us, sorting things a little bit, get an overview on what has been said, but also somebody adding the more of the international, the non-European, maybe even the non-US perspective to the picture, because other jurisdictions are active in the field as well. And I'm very happy to welcome, as the person doing that, Daryl Lim, a long-standing friend and colleague of mine. He's professor of law and chair of Center for IP Information Privacy Law at the University of Illinois, Chicago. he is, amongst other achievements, has been elected as an IP trailblazer in the US, and is also, I think, among the 0.3% top percentage of most downloaded authors on SSRN, or however you may call that or describe that correctly. And both achievements are certainly also due to the numerous papers he has already published on the matter of AI and IP. So from his profound knowledge and background, we'll hear about what he has to add and what we have maybe learned already. Daryl, please, the floor is yours.
Well, thank you for the very kind introduction, Peter. Congratulations to you and your team at SIPCO and IPI for an excellent program. I'm going to say good afternoon because I think the center of gravity is in continental Europe today, even though it's morning over here where I am. And in the theme of food and the table being full, I'll say I'm the amuse-bouche between the four speakers and the discussion. So I'm going to try to keep it light. I'm going to draw on the key themes that you've heard this afternoon. I'm going to try to set the stage, or I suppose in this case, the table for a broader discussion on what's been going on in Europe, the US, and Asia. So I will do three things. I will propose first that the challenge has been set by AI on the status quo. The challenge is inevitable, it's irreversible. Second, some aspects of the change in that you might have read about in the popular literature have been overblown, others have been completely missed. Third, the status quo and outlook with the theme of today's workshop, I think rests on three things: data, data, data. By that, I mean data mining, data protection, and data regulation. So let's start with the challenge to the status quo and why it's both inevitable and irreversible. Well, in Europe, the EPO has received 3 times more applications in AI in the last 10 years. You see even more in the US and in China. In the US, there is a laser sharp bipartisan focus on supremacy in AI. Trump, during his time, issued an executive order to maintain US economic and national security, to shape the global evolution of AI in a manner that's consistent with its national priorities. After the Biden administration took over, you have the Democrats now controlling the Senate. So Senate Majority Leader Chuck Schumer recently led an effort to pass a bill targeted at countering China, and also used the words, "We will shape AI in our own image." So there's laser sharp focus there, and certainly China, and as I will mention later, Singapore are ready to rumble as well. In terms of the impact on IP practice specifically, Denemeyer did a survey. 7 in 10 patent specialists put AI above all other issues in terms of its likely impact on IP work in the next 5 years. We're talking about portfolio management, patent searching, translation, annuity. And in a sense, it's interesting because you would think that most patent applications today are fairly standardized, but the biggest problem they identified is it's spread across patent offices and the patent filings in about 50 different languages. It takes a team of patent lawyers weeks to answer a simple question about ownership, but only minutes for computer program. In Singapore, they've already launched an app that you can download on your smartphone, and you can file your own patent applications. The patent office, trademark office there are already using AI in their search, their classifications. And so the race is on to produce things and go faster, better, cheaper. Interestingly enough, the report that Ryan referenced at the start of this afternoon's session about that the European Parliament released revealed that only about 3% of the respondents felt that the laws were adequate in Europe, whereas the US Patent Office's responses from its stakeholders indicated that people are much more comfortable with the status quo in terms of where the laws are. They think that they are more or less up to speed, maybe a few things to tweak here and there. And I wonder how much of that is a reflection of the divergence in the coefficient of uncertainty, the appetite for change, and just the comfort in being messy. And I think if you look at doctrines like fair use in copyright law, the rule of reason in antitrust law, you get a sense that this is more of a rough and tumble, we'll just go with the flow, we'll figure it out as we go along kind of society here in the US. And perhaps in Europe, there is more of a demand for things to be clear, regulated, regimented, a point which I'll come back to at the end. Now, there is going to be a challenge in 3 ships. I call them 3 ships: authorship, inventorship, and ownership. And we have heard about this as a recurring theme this afternoon. Why teams are getting larger, more diverse, and more reliant on AI as the centerpiece for the creation and innovation process. Well, right now, IP laws recognize the human-centered approach. That's why Ryan and his team didn't do quite so well with their Davos application. And I think there's a general discomfort in the people that I speak to about the impact of recognizing AI as the inventor or as the author, because it upends jurisprudence, it upends people's sensibilities of the human-centered part of this process. Even if you look at life plus 70 as the duration for copyright protection itself is pitched based on a human being. But at the same time, the vision of in authorship and inventorship as utilitarian entrepreneurial means to an end, I think will eventually push this personality-centered narrative of IP laws and will probably win out in this AI age where things are much more focused on the machine than on the human. Now, what was China's answer to this when posed with the question? There's a case in Shenzhen. Ryan referenced that earlier too, but footnote here a little bit more details. Involved Tencent. The plaintiff had used the AI to collect and analyze text structures of the stock market. And 2 minutes after the stock market closed, it's able to put together all that information, churn out an article. The defendant took that article, posted it on the internet. The question, was it copyrightable? And if it was copyrightable, who owned the article? The court said, well, there was authorship, was created independently. There was creative selection, analysis, judgment of the stock market data. So yes, there was authorship. Who owned it? The algorithm gave the technical effect, the court said, to the group's creative work. So the activities were carried out on behalf of the plaintiff. It was supervised by the plaintiff. It reflected the needs of the plaintiff. But most importantly, perhaps, the plaintiff would bear the responsibility of that creation and publication. So the court was comfortable to say this was AI assisted. The person who owns and operates the AI owns it. The AI is a tool rather than the author. And perhaps this is the way we should look at it. An article I read in IP Watchdog referred to AI as like a truffle hog. And for those of you in Europe, I think you know how it works. You bring these hogs out to the field, they sniff, they smell truffle, they tell the truffle farmer, and the truffle farmer gets the truffle. Now, they have intelligence, they have autonomy. Do you know how the truffle hawk is going to work? Well, you can't really say exactly. There's a little bit of a black box there too. But there's no question who owns the truffles. It's a truffle farmer. Same with antibodies that you generate by injecting antigens into experimental animals. You collect suitable B cells. The researchers, in fact, can't control how the antibodies are generated. The animal's immune systems should take the credit, but does it make them less qualified as inventors? No. So we have that framework that how the law progresses is incrementally, not exponentially. And so the IBM, in response to the USPTO's request for comments, actually suggested, why not think about a work for hire like framework in patent law? You recognize the legal person, as Beard put it, as the inventor, as the owner. And US patent law has this idea of shop rights, where something that's developed by the employee while under the employee is under the ownership of the company. A car factory that puts out fully automated cars or cars in a fully automated assembly line is owned by the car company. Same idea. Now, how will we know? We won't know. Unfortunately, inventorship issues don't come up usually when it's prosecuted. It normally comes up during litigation. So it might well be that only when it goes before the court will you determine whether or not you in fact had a patent. Now, point number 2, some aspects of IP are overblown, others ignored. Where are they overblown? We read often about Section 101, but I think Section 101's case law has been made clearer. Under congressional pressure, you will see further inflection points in the coming year, whether it's by the Federal Circuit or whether it's by the Supreme Court. In hardware, we know that with AI, you implement the AI as part of a greater system where the AI provides the technical solution to a technical problem. That's why you speak to people like Kate, she'll want to know how the technical effects work in the invention, because she knows that that's what the courts and the patent office, in fact, are looking for. With software, you focus on a specific application and you avoid preemption. There are any number of cases today that indicate how, if you do it narrowly enough, whether it's the lip cinching cases or other cases, you can more likely than not be able to obtain and keep your patent. With 103, they say it could be a game changer. Everything is rendered obvious because you now have AI and AI is omniscient. Well, if you read the interview that Ryan Abbott did with Gilbert and Stroud not too long ago, he recognizes that this too is probably overblown because, in his words, if a company is using exceptional proprietary AI, the system shouldn't set the baseline for whether something is obvious because it isn't something that society has access to. So yes, you might have isolated instances where 1 or 2 companies have access to that, but it's by no means a reflection of a skill of a person or the ordinary skill in the art. With 112, they say it's difficult to disclose. Why? Because the input and output might be known, but the logic in between is not. And sometimes you can't properly disclose it because the data set is proprietary or the data set is barred by statute, whether there's some trade secrets in there or because there's a HIPAA restriction. Well, what are some of the solutions that we propose? You can describe the data set in sufficient detail so you can produce an equivalent data set, or you can disclose a commercially available proxy, whether you're talking about the number of types of layers, neurons, interconnections, trigger functions, and so on. With trademarks, something which has not been quite talked about as much today, I think the consensus is it's going to be relevant as for such an examination. But one thing which I think has not really been on the radar of many commentators, if at all, is the function of trademarks really are heuristic for human beings who have limited cognitive powers. Those of you who are familiar with behavioral economics, you know what I'm talking about. We use these trademarks as heuristics to navigate a very crowded and complex marketplace. Human cognition is limited, a trademark is useful. So you think about Apple, you think about a good quality computer, you think about good quality phone, and if they produce something else, you extrapolate that quality to them. But if Alexa is making those purchasing decisions, or Siri is making those purchasing decisions and not you, it is able to fully manage the purchasing choices. It's trained on your preferences. It can extrapolate to goods and services that are likely to please you It may make a mistake from time to time, but soon enough, it will outperform you in predicting what you like, because it can accumulate data at a low cost, and we have no need to rely on trademark's ability to convey the affiliation information, because to computer, strings and numbers functions just as well as the word apple. So it could be an existential issue for trademarks. Third, AI's outlook in Europe, US, and Asia depends on three things: data mining, data protection, data regulation. With data mining, the approach is data is a grist for the mill, which means you use the training data. It is likely regarded to be transformative because it's placed in a new context to serve a different purpose, not copyright infringement. But hang on, say the copyright advocates, because anytime you copy, you would implicate the reproduction right. And the author should be allowed to share in the revenues generated by the AI in a way that cars need to pay, or buildings need to pay. Cars need to pay for the gas, buildings, you still need to pay for the electricity. So please give us our due when you use our works. There's a lot of uncertainty, many parts of the world. In Singapore, they have taken the move to say we're going to have a safe harbor for both commercial and non-commercial data mining. I think it creates that certainty. I'm sure that it has broken. Both sides have come together, including the authors, to say, okay, this is workable. These are the parameters. Of course, it has to be obtained legally. Compared to the Digital Single Market Directive, it allows commercial text and data mining only if the rights holders do not opt out. So certainly a lot more restrictive in Europe. And concern is that going to undermine Europe's competitiveness? Second, data protection. Well, Europe, I think in 1996, decided it was going to try to protect data by a sui generis database right. No other country, to my knowledge, has taken it up. And so I think that might be a cautionary tale. But on the other hand, Europe has a powerful lever in being more able and willing to pry open the coffers of companies with data using competition law than in countries like the US, where the essential facilities doctrine is a bad word. So what's going to happen there? We don't know. We have certainly seen countries like France, Germany, and elsewhere taking a rather robust approach to digital platforms. What does that mean for AI and the data sets related to that? How is that going to impact the development alongside or irrespective of what happens with what we're trying to do with IP and AI? Third and final point, data regulation. Europe has its AIA moment, not America Invensec, but the AI Act. This is a high stakes gamble. Europe is signaling to the world that it believes that more regulation is better, in contrast to the United States laissez-faire approach. It believes that you need to roll out and develop AI by building trust and by having clear rules for the road. But people outside of Europe are concerned that the rules are strict, they are complicated, and they may in fact not only stifle Europe's competitiveness, but catch many other countries involved in Europe's markets as well. The costs for compliance, according to an EC-sponsored study, is $400,000 upfront just to set up what's called a quality management system. You need to test, you need to train, you need to validate the algorithms, you need to ensure human oversight and meeting standards of accuracy, robustness, and cybersecurity. And businesses need to prove that AI conforms before placing it on to the market. Few startups, SMEs can pay the admission price to play, and that's not even counting the price of compliance. And it goes even beyond the GDPR in terms of its penalties, fines of up to €30 million, or 6% of global annual corporate turnover, whichever is higher. Companies that feed into Europe's supply chains are going to be affected, and it potentially exposes the data that it gets to hacking, because we all know and remember what happened with the European medicines agencies, because regulators are prime targets for cyber criminals seeking cutting edge technology. And with ransomware just knock or a turn of a newspaper page away, it's something that's very close to where we are right now. In contrast, the US has taken more of a piecemeal approach. During the Obama administration that was set, Trump continued with it. Biden is likely going to continue with that as well. So in conclusion, let me say that business leads will shape the law, but AI will always move at the speed of trust. And I think it's useful to bring this analogy because in Singapore, land scarce, water even more scarce. It had to solve its existential water problem by recycling every drop of water, including water from the toilet, which they recycled into drinking water. It started off 5% of their needs. They had to convince their population. This is new technology. This is something you should come on board with. We are going to be open, transparent about it, and this is why it's safe. Today, 40% of the country's water needs are met using that. So the adoption of AI and its new regulations, whether it's IP or otherwise, will move at the speed of trust. What we're also going to see, since this is an international segment, is a competition between countries and competition between the values that those countries hold. Each of these countries, Europe, the US, China, elsewhere, will have to contend with the issue of AI challenging the status quo in those countries. They're going to be inevitable. They're going to be irreversible. Some aspects are going to be overblown, others ignored. But both the status quo and the outlook in each of these places will rest on three things: data mining, data protection, data regulation. And as we come into a time of discussion, I want to again thank CIPCO and IPI for bringing together people across sectors, across disciplines, and across countries. And I hope and look forward to a nice discussion. Thank you, Peter, and thank you all of you.
Well, our thanks to you, Daryl, for this excellent presentation. Not only a good tour d'horizon of what is out there and what has been said during the discussion so far, during the presentation so far. I found it particularly interesting to hear about the international approaches by different jurisdictions. And I think it's also always good for us Europeans to have our ways questioned a little bit, and to be shown that other countries and major countries for that matter, do things differently in a way that we might find murky at first sight, but which might actually arrive at better results, both for the international competitiveness of those countries and for their societies, actually. So that was most intriguing what you said. I mean, you know that I will thank you in the end, but right now I would like to extend thanks already to all speakers for their excellent presentations. I think we really have very good stuff on the table now for discussion. You probably don't know because you haven't been in the organizing loop, but Felix hinted to it. You don't know that we would have, we originally planned to have 3 days for this event, 3 live days, and that had to be shortened to 1 afternoon online. So we have too much material for too little time, but which conference ever was not in that predicament? So we have heard a lot. There is more to say, and we want to discuss. Our idea was to start off the more interactive phase of today by short interventions combined with questions that add in a short way some additional facets to the picture. And but right after each intervention, during the interventions, and after their end, you are absolutely free to ask questions. We're happy to learn about your views. So go ahead, fire at the speakers with your questions. And with that said, I would like to open the Q&A and give at the same time the word to Hans-Uli Stamm, the chief economist of the Swiss Intellectual Property Institute, who might want to say a few words on the administration's view on all of that. Hans-Uli, please.
Thank you very much. It's fascinating to listen to all these different ideas and how we could approach the whole story. Let me go a little bit more down to what we are doing. As Felix mentioned in the beginning, we started at around 2016-17 to think in an institutionalized manner of everything connected with AI and, by the way, other new technological topics. There are two good reasons we saw why it is really worth to think about. And one reason, you mentioned it, Peter, is that AI is also a tool just for us. And the second one is AI is challenging the IP system, the policy perspective. The tool dimension is clear. We are at the moment experimenting, evaluating tools that might simplify the life of our examiners in the trademark and patent department. But it's still in a very experimental phase. Our first goal is to digitize all our processes, because that's the precondition to use AI tools. And the second problem is we are a very small IP office. And to use AI tools, you need a lot of data, a lot of examples, a lot of documents you can feed the systems, and that's a problem with even a country with 3 languages. So you even have to train the system with 3 languages. The more interesting point, also the area where Felix and I and my colleagues are working in, is this policy dimension. And also in this policy dimension, there are 2 aspects which are important. There is the Swiss aspect, because we are part of the Swiss administration, and there is the international aspect, because we are representing Switzerland in international fora. The Swiss aspect, as I said, we are part of the Swiss administration, and the Swiss administration of the Federal Council, this is the ministry, the colleagues of the ministers, they published recently guidelines or digital publication and guidelines for the Federal administration, how they intend to implement AI technologies in daily business. There's a strategy of this Federal Council, and the Federal Administration is now asked to implement this strategy. And of course, our task there is to have an eye on everything that is connected to IP, in order not to be present in this discussion. Our last contribution to this national discussions on AI and IP is a publication on non-personalized data, which is not directly linked to AI, but it's an important ingredient, of course. And what we did there is we looked at the market in Switzerland, whether there is a market failure to be observed and whether there is state invention necessary. That's usually at least the economic approach we follow. Let's see whether there's a market failure. Otherwise, there is no reason to intervene. On the international dimension, of course, we follow what's happening in the different international organizations, the WIPO conversations, what the EPO is doing. There is a recent discussion on UNESCO on the ethics of AI, which also deals with IP, of course, and also some strategies of national IP offices. Ryan mentioned some of them. We are just looking what they are doing. the question is, if we observe the development of what's going on, what is an indication that something is going wrong? Because observing is nice, but only observing doesn't make sense. So then is a criteria needed when we have to go a little bit deeper. And this criteria is, as I mentioned, market failure. The problem is, what is the reference to market failure? And usually is it market, are they efficient? Are there not enough incentives that might lead to an efficient result? Or is there no more market failure anymore because the technology is in a stage that the market failure that used to be in this area abolished? That will be probably one of the topics we discuss in one of the next workshops, online workshops. So if we find evidence that there is of a looming market failure, and of course we get the mandate to make suggestions for improvement, then one of our basic principles is technological neutrality. So we probably won't do a special law for AI regulation, but we would probably put that together in a regulation that is technically neutral. The technical development is so extremely fast that if we regulate today something, the day after tomorrow, it won't be usable anymore. So our legal framework is relatively stable, and that's what we would like to keep on for the future. Though that, in a very short nutshell, is what we are doing at the moment. So active listening, as I said, and that's why I'm so happy that all of you are here and sharing your ideas with us. There's a lot of colleagues of mine, they are making notes, and we will bring that together. And of course, it influences our knowledge, and our knowledge is the base of what will happen or what we will recommend to the policymakers if we see is a necessity to change something. So that's really nutshell. Thank you very much for being here, and I'm looking forward for the discussion and the other workshops in this series.
Thank you very much, Hans-Uli. That was an interesting nutshell description of the quite active listening position the authority is in at present. And I think the support you give for that research project here already shows that you're an active listener. Unless there are urgent questions right now to Hans-Uli Stamm, I'd maybe first call in Florent Duvenin with his contribution to the discussion, maybe including questions to the authority already. So Florent, please.
Okay, great. Thanks a lot. Well, first of all, I would like to thank all the speakers once again for their very interesting talks, and most importantly for kind of providing the floor already for what I wanted to bring to the table. It's quite interesting, I think, and remarkable to see that even the colleagues from the US, so most importantly, the colleagues from the US are very well aware of what is happening in the EU AI regulatory landscape. We all know that AI is a key challenge for society, not only in IP, but also in many other areas. I would even say that challenges outside IP are much bigger and more important for society at large than the challenges we are discussing this afternoon. Think, for example, of AI that discriminates or manipulates individuals. And that is, of course, also the focus of the current regulatory discussion at the EU level. Against that background, many legislatures around the globe are currently thinking about if and how the use of AI should or even must be regulated. And as mentioned earlier by many of the previous speakers, we now have a first draft, a draft from the EU Commission that has been published very recently, actually on 21st of April, based on a relatively long-lasting discussion, white papers published roughly a year ago, etc. But we now finally have a draft from the EU Commission, and it will be very interesting to see what happens with the draft in the course of the next few months, because of course the draft will then have to also be adopted by other EU policy-making instances, including finally the Parliament. As we have heard earlier on, the draft EU AI Act actually covers various issues, and it aims at regulating the use of AI as such. So it's really oriented towards regulating a technology, which is, at least from a Swiss perspective, somewhat unusual. We would probably rather look at specific problems that may be caused by technology, but we would rather not try to kind of regulate the technology as such. However, the EU follows this approach, and the AI Act basically consists of two parts that have been mentioned already to some extent. So we have basically 4 cases where we have prohibitions of some AI uses. And then on top of that, we have quite far-reaching requirements for the use of so-called high-risk AI. This is why the risk-based approach provided by the EU, or used by the EU, has been mentioned earlier on. Now, with regards to the 4 types of prohibited uses, we have a relatively broad, somehow very unclear clause that tries to prohibit any sorts of manipulative uses of AI, at least if they come with risks for physical and mental health. And if you read that clause, well, you will ask yourself, well, I have no idea with regard to what the scope of application actually is, but it is probably still relatively narrow because it only applies if health, mentally or physically, is at stake. And then if you look at what the EU Commission presents as examples, when talking about that clause, you realize that maybe they have a much broader interpretation than one would think of in the beginning. Second point, uses of AI should be prohibited that would exploit the vulnerabilities of a specific group of persons, namely due to their age or physical and mental disabilities. Third group, AI may not be used for social scoring by public authorities. And fourth and last group, the use of real-time remote biometric identification systems for the purpose of law enforcement, namely facial recognition, should also be prohibited, but there are, important restrictions, namely when it comes to protecting national security. So 4 types that should be, prohibited relatively straightforwardly, and then in addition, and more importantly, the Act contains also rules for so-called high-risk AI. And the key question here, of course, is what is high risk? There are 2 approaches. One is an approach that tries to define high risk by saying AI, we have a high risk AI component if an AI system is a safety component of a product and if that product must undergo a third-party conformity assessment. So that's kind of the abstract definition of what high risk means. So if AI is a safety component, then it makes sense to say if that component actually fails, then safety is at risk. So we have probably high risk for whatever health and mental and physical security. But in addition to that, the Act also contains an annex, number 3, that consists of a very broad list of AI systems that are considered to be high risk. Some of them have already been mentioned by some of our colleagues that talked earlier today. And they include all uses of AI for education and vocational training, for employment and workers management, for access to and the enjoyment of essential private and public services, so potentially extremely broad, for law enforcement and also other fields. So the notion of high risk is, as you can see by these examples, very high, and the EU Commission also reserves the right to add, other items to that list if they seem fit. Always based on what we have today. It's just a draft, but still, it is a first draft, and that is what we can discuss right now. If we have a high-risk AI system, that system needs to meet a series of requirements. Some of them have already been mentioned. There are, amongst others, there's quality criteria of data that AI is trained on that need to be met. There is a requirement of automated recording of events, so logs must be kept to make sure that if anything goes wrong, people will be able to understand and find out and also prove what went wrong. And then from the IP perspective, particularly interestingly, AI systems must be sufficiently transparent to allow users to interpret the system's output and to use it appropriately, then human oversight must be guaranteed to prevent and minimize risk. So the Act very much still is based on the assumption that technology is more problematic than humans. So every technology must come with some sort of human oversight, because the human then could prevent bad things from happening. A few question marks might be added here, I guess. And then last but not least, Daryl has mentioned that AI must meet an appropriate level of robustness, accuracy, and cybersecurity. But the Act does not address IP issues. So what about that? One key point from my perspective is that the AI Act requires transparency on various levels, and there are also additional, of course, transparency levels provided by the GDPR, so the General Data Protection Regulation. They play together. However, if you look at these transparency requirements, we can probably assume that they are kind of below those, of disclosure in patent applications. So I'm not sure, although nothing is sure yet with regards to what the Act actually means. But I don't expect these transparency requirements to go further than what would be required with regard to the disclosure and patent applications. In addition, the EU Commission also states, in the explanations to the draft Act, that the transparency obligation should not disproportionately affect the rights to the protection of intellectual property, since transparency, based on the AI Act, should be limited to the minimum necessary information for individuals to exercise their rights. So one could say, relax, not a big deal from an IP perspective. I think, however, there are two exceptions. First, it's unclear if and to what extent the use of AI for research and development at universities and also in the industry is also covered by the Act. The Act generally focuses on the placing on the market of AI systems, and it may well be argued that research and development do not fall within the scope of application, but that seems unsure, not least since the AI Act does not contain a clear exemption for research and development, and it does also not address the issue of research and development in the recycles. And that is one reason why a group of universities, of European universities, will provide a statement to EU Commission, which basically asks the Commission to consider making a clear statement, at least in the recitals, with regards to research and development not being covered by the EU AI Act, at least if research and development is taking place at universities. The other thing is that the transparency requirement, provided for in the Act may make trade secret protection for AI inventions very difficult, maybe even impossible. But the impact of these transparency requirements on whether trade secret protection works or not will, of course, very much depend on how that transparency requirement will be conceived and enforced in the future. So there is a lot of uncertainty in this respect, at least for the time being. Finally, all the requirements of the EU Act that I have mentioned will have to be taken into account when developing AI products in the industry, since these requirements will need to be met once the products are put on the market, at least if it is, if they should be put on the European market as well. Because, Europeans have learned some time ago from the Americans that it might be a feasible policy option to make sure that their laws also apply abroad. And Europe has been quite successful in this respect with regard to the GDPR, and they follow the same approach also here with regard to the AI regulation. And from that perspective, and the perspective of making sure that while developing AI products, you must take into account the requirements that need to be met once you put these products on the market. So from that perspective, the Act will also have a major impact on research and development, and thus finally on IP. So I'm very much looking forward to the discussion. My question here would be, of course, how do we try to tackle that tension between transparency requirements with regard to the use of AI, also based on data protection law on the one side, and to protection of trade secrets on the other side. Many of the questions have been, kind of maybe not really mentioned yet, but there's many other issues that have been mentioned that we can discuss, and I'm very much looking forward to that. Thanks a lot.
Thank you very much, Florent. I think Begonia Otero would have much to say about your topic and also your question. But before that, we have a direct intervention by Beat Weibel. So please go ahead.
Yeah, thank you very much, Flora, for sharing this. I mean, I just feel compelled to share my immediate reaction on what you shared with us. Honestly spoken, this over-administrated approach, I would say, of the EU AI Act is a guarantee to lose the race in AI globally. That's my immediate reaction on what you just presented. I don't know how others see that.
Can I react to that?
Sure.
I agree. And you know, I think what is, you know, bothering me most of all is that we have had a similar situation in the course of drafting the GDPR. And very shortly after the GDPR has actually been enacted, it had not even entered into force because that took another 2 years. Angela Merkel by then said, well, okay, now we have this big, you know, piece of regulation, but we must make sure that this does not negatively interfere with Europe's ability to innovate in the data space. Yes, true, but of course interference is there. And I fear that we will end up with a similar situation. However, you know, I have not followed all the pre-drafts, etc., very closely. Other people have had better ways of accessing the information. But what I know from discussions with people who have followed this process more closely is relatively clear that what we have now as a proposal goes a lot less far than what was initially proposed. So the reduction to, you know, only regulating high-risk AI is already a big step forward towards allowing for more innovation. Although I fully agree, it is still very restrictive. And, you know, I'm working on proposals with regards to how we could react to that draft in Switzerland. And the main stake of our group here would be that we should not regulate the technology. We should look at potential negative impacts, harms that can be caused by the use of AI, things like discrimination and manipulation, or maybe also specific damages. And we should only look at these, therefore allowing for as much leeway as possible for research and development in that space. And I guess that would also be your approach, Beat, and probably also the approach of other people from you know, businesses trying to invent in this space.
Mm-hmm. Mm-hmm. Yeah, one sometimes really worries about the jungle of various regulations and rules and obligations that the EU is creating right now. I mean, I'm for other research work, I'm just digging my way right now through the DMA, the DSA, and the DGA, and the InfoSoc directive and whatnot they reference to, and you have all those, you know, various transparency obligations and enforcement rules and so on, and differing authorities with the obligation to apply these rules. And then of course the Commission always wants to have kind of a say in the thing, and then you always have that big giant of EU competition law looming in the background, because everything can be anti-competitive what you do there. So it's sometimes, you know, I mean, maybe, sorry, I stopped speaking in a moment, give the word to you, Begonia, but maybe the you know, GAFAM, they can manage this, maybe because they have the resources to have various legal teams for each piece of regulation that the EU comes up with. But I'm sometimes worrying if even, you know, big players like Novartis or others would be able to properly deal with all these I would say partly non-coherent obligations, right? So I mean, one thing is the level of legal control we want to establish for upcoming technological and business approaches. But the other thing is to have a manageable and coherent legal framework that you can at least, you know, apply if you try to, right? But sorry, that was just my 5 cents for the moment. Begonia, you have the floor.
Thank you, Peter. May I share my screen? I mean, I only have 3 slides, but just
go ahead.
I would like to share, and actually then most of them. So now you can see. I mean, and I partly agree on the comments on the AI regulation, the AI proposal, and all this jungle of new proposals. You forgot about the Data Act, that it's also upcoming. So we have another one to add. But and I'm not 100% sure how this risk-based approach of the regulation will work, because it's just a jungle of these 2 annexes and the regulation. I started studying it 1 week ago, and it's a nightmare. I mean, I've reached Article 10 and going back and forth from the annexes and say, okay, I need a break. But I would like to make this my intervention slightly different, and I would like to start with the news that appeared in a German newspaper last June 7th, and of course in many other newspapers, that relates to Bosch opening a new chip factory in Dresden. And the thing is that the European Commission is also, it's behind it, and is very concerned about Europe's increasing dependence on microchip from overseas. And you might wonder, we're talking about AI, so why am I bringing news about a microchips factory instead of talking about algorithms or data, or a new AI breakthrough that we have seen from other speakers? Well, in order to answer, I need to refer to another event that took place also early this month, which is the Computex. Computex is one of the most famous computer expos that takes place in Taipei since the early 2000s, so around 20 years from now. And the main topic of these years has been one of the new morph combination between AI and AIoT, that it's known as AIoT, so artificial intelligence of things. And it's estimated that by 2025, so in 3-4 years from now, this is going to be a $3 trillion industry. And a part of the reason is big data. So again, as Daryl said, it's data, data, and data. And its impact and the value it brings to someone who controls it or owns it, whatever we want to call it, or has access to it, learning from it, improving. And the thing is that also it's making decisions in almost real time. Because when we add artificial intelligence and we can embed that and enable that to be part of an IoT device, then the IoT device can analyze its own data. And that means that the latency is reduced, because we don't need the IoT device that only collects the data, that also needs then to transport it to the network or to a data center or to a database to be analyzed by humans or potentially by any other AI system. So this idea behind AIoT is that we eliminate the middle step and we embedded AI or the algorithm right into the IoT device. And one would wonder, no, so why does that matter? Well, because when we put a brain inside that IoT device, so it's not only collecting data, but it's making the decisions in the device. And until very recently, part of the reason that AI had not been embedded in IoT, it's been, as always, a hardware issue. It's a computing issue. We did not have low chips or low-cost chips or small enough to incorporate and embed into IoT devices. No, it's these kleine chips, die große leisten, or we can say in English, no, small chips that do big things. And another thing that we're going to start to see in the next year or two, and that the COVID-19, the pandemic has also boosted, is an entirely different type of service. Right now, we all have heard about software as a service solutions, and they have been really relevant to the development of both IoT and AI. But now we're going to start to see what it's called DAS, and that's not device as a service, it's decision as a service being offered and made available through the IoT network or the device. So we're going to have components embedded like the chipsets and the programs there. And my prediction, or what I think it's going to happen, or we see, is the development work on APIs to extend and flex these IoT networks. All of these at the end translates into more efficient, quicker processing of big data. And here, one could wonder, so what are the IP issues when we're moving into this IoT reality, when in the current legal framework? And probably many of the current problems that have been addressed today and related to AI-assisted or AI-generated outputs in terms of human authorship or inventorship, and I mean, they might even intensify. Even the transparency problems might even intensify if the data it's just located there and it's processed and the decision is made there. And in this jungle of these European, at the European level, where I try to concentrate, the recently published impact assessment of this upcoming Data Act proposal that was recently published now in May, it stresses the need to tackle some obstacles that are linked to the access to and the technical and legal ability to use data. And again, I think this is going to be one of the key issues that we're going to face. And on the technical side, they stress interoperability, also safety and security requirements, while on the legal side, they stress the uncertainty that we still have about rights on data, compliance with existing legal obligations, and licensing costs. On top of that, we know that the EU policy has increasingly focused on the role of this database directive and in different typical big data and AI use scenario. We know that the Commission evaluation of the database directive and also the academic evaluation report has shown that the database directive it's a case for imminent reform. However, concentration only on this database with generally, although it's most imminent problem in EU IP law, might fail to see the whole picture. When we're talking about access to data and the development of data markets, when we're looking at these AIoT, seems much more relevant than just looking at AI. In general, we're going to require free and accessible infrastructures for the exchange of data between different market players. Yet, problems concerning this infrastructural framework for data access, sharing, and reuse, and data interoperability should not arise from existing legal barriers to access to a specific technical infrastructure, such as the APIs or data standards. Today, however, technical interfaces are of strategic importance for ensuring accountable and trustworthy AI. And in that regard, the role of copyright and patent law, but especially trade secret protection, can be detrimental. Yet, probably copyright and patent are not the real issue here, because the truth is that without legal intervention, APIs need no disclosure, and access to them has to be requested on a contractual basis. And this allows for information hiding. And this also means that reverse engineering becomes futile. It doesn't work if the software is provided as a service. And even more, if the software is provided as a decision, there is no reverse engineering possible at all. And this brings us back to, again, competition law and the refusal to deal cases where this traditional question of using the information for the facilitation of vertical or horizontal interoperability becomes relevant for enabling intra or inter-brand competition. So when looking at the future outlook, it seems to me that trade secrets position themselves as on the one hand, as a defensive, but also a more flexible hybrid regime, which might be better equipped for the data economy. On the one hand, as a hybrid regime, trade secrets protection does not constitute property rights in rem, as legally we refer to them, but instead, they only complement and intensifies de facto exclusivity because of secrecy. Accordingly, it does not vest an exclusive right in the person or of the trade secret holder, but it only provides for defense and remedies against these certain prohibited acts of misappropriation by third parties. So far from a disadvantage, this system or this flexible character and hybrid character invites into contractual relationship with others, which some of the speakers refer to from the industrial point of view, that the need for collaboration, and that means the need for contractual relationships. Yet, from a European point of view, even though the Trade Secret Directive intended to harmonize the regulation of trade secrets, at the end of the day, the level of harmonization that its instrument has achieved is very limited, given the lack of definition of concrete and uncertain issues that have been left to national legislators. For example, concerning the legal qualification of trade secrets, there is no notion of ownership of an intangible thing in some countries, such as Germany, and in other countries, such as Austria or France, it's possible to be the owner of such an item. And this results in significant difference in ensuring the protection of trade secrets on an international level. Thus, in the realm of connected devices and all kinds of data-related networks, as we can see here in AIoT, and this is what it's coming, it will often be very difficult or even impossible to identify the person or the persons who lawfully control the respective trade secrets. By contrast, its characteristics for the input to and the use of data in data-related networks, that a transparent allocation of rights to specific parts on the data pool, for instance, will often simply no longer be possible. And in that regard, it seems that only contracts and private ordering instruments could solve the problems related to allocating these ownership shares and these mutual relationships. However, the Trade Secrets Directive does not contain any provisions on licensing or other contracts in the field of trade secrets ownership and use, which its main shortcoming, I will say, for the data economy. In the European Data Strategy from last year, from February, the European Commission proposed a review of the Trade Secrets Directive to determine its role as a framework for data sharing and exchange. Well, I think the purpose of trade secrets and contract law in a world of morph technologies, such as the example of AIoT, it's going to be essential. And future questions may arise concerning trade secrets and the protection of data, but also algorithms and even source code, because that's how algorithms or machine learning algorithms are expressed in source code. So my question to all of you, having so many experts among the speakers today, will be, what do you think should be the direction, if any, of the legal framework on trade secret protection in EU, but also beyond the EU? And what do you think should be the way to go in trade agreements and similar international agreements where clauses related to trade secrets and AI accountability can also play an important role? Thank you.
Thank you very much. That was really much food for thought. A mega intervention, so to speak. A very interesting question you posed to the speakers. I mean, one additional point that was hinted to several times during today's presentations, and that is maybe even a bit more fundamental than your final question, although you also touched upon it, and that we may, just tag to your question as a second question. This shift towards the use of trade secrets instead of, for instance, patents. It seems to be something we are experiencing. I mean, that's what the statistics tell us. That's what, in part, the speakers have told us today. Is this really something we want? Do we want something that is relative, something that doesn't come with disclosure, something that is, as you have very, excellently described, that is in a legal framework, embedded in a legal framework that partially is not a framework, but more a combination of legal uncertainties. So is this, before we ask how we should reform trade secret law to better cope with the issues, is the move towards trade secrets something that we should, combat, to overstate things? So I would permit myself to tag this question to your question, and giving now the word to the speakers, we could maybe start with Beat Weibel and Peter Thompson, because they both raised their hands. And so I would say one round of speakers' comments on that, and then we have a long-standing question already by Mr. Spennemann. So please, word to the speakers.
So if I may take the word, so to speak, I personally feel that trade secrets in terms of alternative of patent protection for software are completely overstressed. And in particular for artificial intelligence, this is also true because as we learned, artificial intelligence or artificial intelligence inventions are mainly software implemented inventions. But my experts, the software detection experts, tell me that each and every piece of software can be decompiled within necessary time of, let's say, 6 to 12 months. And this can be even accelerated if you use AI tools to decompile the software. So there is not really a good protection by trade secrets for source code and software inventions. Trade secrets are a good measure for, let's call them business secrets, but certainly not for software or AI inventions, according to our experience. Thank you.
Peter Thompson.
Yes, thank you for those interesting thoughts. I start with a small question, which you may respond later, Ms. Otera. If you could give us one example of this new AIoT decision making, I would be interested to know what type of decisions that could be an AIoT tool could do. But now to your questions. I think you're right. There is an inherent tension between, on the one hand, the transparency we would like to have, or which is required now, requested by the EU Artificial Intelligence Act on the one hand, and the trade secret protection. And I see this particularly in the case for the algorithms themselves. Because the algorithms, in Europe at least, it's clear you can't have a protection per se on the algorithms themselves under patent law. Copyright also probably not. So what is left is trade secrets. And if that works, it's all fine. But if for other societal purposes a disclosure is desired or needed or required for safety or for, yeah, if it has to do something with health, then then there is probably no protection anymore for any algorithm. And then the question is that enough incentive to create new algorithms, or will this become a market failure finally? We don't know that, but there is at least I would also clearly see a risk into that direction. And then to your second question, I think that is already far looking. Also, it's an obvious dimension of the whole thing. I mean, we are talking here about connected information. We are talking about data who are not anymore restricted by country borders. I mean, they are floating in global networks, and therefore international rules are finally very necessary, also for businesses to have the necessary certainty wherein to work. So, but as long as we are not clear in some leading jurisdictions how this will be regulated, it's difficult to come up with some international standards. But yeah, maybe this needs to go in parallel on this important topic.
Thank you. Ryan?
Yeah, just briefly to weigh in and not to take time from Christoph, but I think it's difficult to paint broad strokes, and this really is a case-by-case thing, but sometimes it works and sometimes it doesn't. So if you really have software as a service behind firewalls and you don't have a lot of risk of disclosure or unauthorized access, which of course you really always do, maybe sometimes it works. But the cases you heard today from Beat about the car suspension, or Peter about AI developing a new drug, those aren't really products that you can protect with trade secrets. Once they've been disclosed, they've been disclosed. And if they don't have a patent, you've got a real problem, right? So not every industry is the same, but at least some of the time that's the problem. With our test cases, people have said, well, but DABUS is patented and DABUS has copyright protection. And, what do you need protection for AI output of when you have all this protection for AI? But of course, you know, our inventor could be licensing or selling his AI to someone else, and really the output has an entirely different protection mechanism and commercial need than the AI itself, you know, as in the case of a new drug. So I don't think trade secret protection replaces patent protection.
Okay, thank you. I don't know, Daryl and Kate, would you want to say something on that? Kate? Guess you're still muted.
Yes, no, I just agree. I don't have anything more to add. I agree with everything that was said.
Concurrence.
Yep.
Daryl?
I'll just say this quickly, and in the international context, since that's the hat I'm putting on today. We should look at current developments with respect to the global minimum tax, which the G7 country leaders are discussing as we speak, and see that as a cautious optimism that multilateralism is not dead. And I think if there's one area in which we need minimum standards, we need harmonization, we need cooperation, and we need trust, strategic trust, it's in the area of AI, for the reasons that I think all of us have talked about, because it affects every aspect of our lives in a way which even 30 years ago or 10 years ago, it's not. We're no longer talking about the IoT, but the AIoT. And therefore, if we are able to move forward, we need to look back. We need to look at the time that countries of the WTO did come together once to agree on this minimum standards for IP protection called TRIPS, 1995. It's a long time ago. Since then, multilateralism seems to have taken a backseat. Moving forward with regionalism, we've got the TPP, we've got the RCEP, and maybe that's a good place to start. But eventually, I think, unless and until we approach AI the way that we're approaching, not 6 months ago, but right now, and hopefully 6 months from now, the way we're approaching vaccines and the pandemic, in being more big-hearted, in being more inclusive, in being more willing to engage, I think you're going to have different pockets. You're going to have parallel streams, a decoupling of supply chains. And I don't think that any of us will be better off as a result of that. And therefore, again, Peter, I would say congratulations on putting together an urgently needed focus in bringing together groups like ours and those people gathered here, not just for this, but your whole series of presentations. Indeed, I think Switzerland can punch above its weight. It's small, it's nimble. Show Europe how to do it right.
Thank you very much, Daryl, for those flowers, not only for the event, but also for Switzerland. I gladly also hand part of them on to the IPI. We have Christoph Spennemann having waited now for a long time. Please, you have the word, and after that, I have a hand raised from Ryan Abbott.
Thank you very much, Peter, for giving me the floor despite the late hour. Christoph Spennemann from Swiss IPI. I promise I won't keep you long. My question was really triggered by Peter Thompson's presentation, who mentioned the issue of disclosure of the invention and the specific problem of submitting an insufficient amount of training data. I'm wondering more generally, how do we meet the disclosure requirement in patent law in the case of AI that makes increasingly complex decisions on its own that we may no longer be able to follow in every detail? So this well-known black box problem. Do we need to allow more flexibility on the degree of what needs to be disclosed? I think Kate, in her really interesting presentation, I think she dealt with this question. Kate, you suggested trade secrets as part of the solution. Now, I think we heard after that from a number of speakers that they don't consider trade secrets to be the great solution because they don't provide sufficient protection. I think seen from the other side of the coin, of course, we also have to bear in mind Article 7 of the TRIPS agreement, which says that part of the objective of IP protection should be the dissemination of knowledge. So there, I think patents play also an important role through the disclosure. requirement. And I think that's why it's really important to figure out how we can use patents in that sense. And Kate, I think there you also made a very interesting proposal using product by process claims. This is, as far as I understand it, a very European kind of specific claims format. And it would be interesting to discuss more how this can be used more broadly also in other jurisdictions. I realize this goes way beyond what the time we have now, but this would be my observations. Thanks very much.
Okay, thank you. Peter Thompson, direct reply there.
Yeah, well, to the black box problem is, I agree with you, is a real challenge for inventions where the subject of the invention itself is an artificial intelligence system. So the subject of the invention where you cannot fully describe what is happening. On the other hand, we have that already today. We had that in the past. For instance, in the biotech field, in 30 years ago, you had a way to create mutations just by having some bacteria being exposed to radiation. And then you got a variety of mutants. You couldn't predict in which way it would go. You had to select out of those. And then you got to your invention maybe. And that was enough, that was regarded as officially disclosed in most cases, in order for a skilled person to repeat it with the reasonable, without starting a whole research program. I mean, that is always the standard, I think, in patent law, and that patent law standard should probably be the same for artificial intelligence systems. How to implement it, yeah, I think this has to be developed. You need probably a mixture of having some description of the structure of the artificial intelligence system, so the layers and so on, you can describe it to a certain extent, and to have some form of training data, so or some teaching how training data could be generated, so that a skilled person could have a chance with some efforts to repeat the invention, and therefore you have fulfilled the disclosure requirements. But another alternative which has been proposed, discussed, is to have some form of repository for training data, a system comparable to the microorganisms, for instance, which you also cannot describe in all details. You just, under the Budapest Treaty, you deposit it somewhere, and then people have limited controlled access to that, other third parties, in order to repeat the invention. That's also possible, but we have to develop that in the future, in my view.
Okay, thank you much. I see a raised hand by Kate. Is that still okay?
Yeah. So I appreciate the questions. I think those get to interesting and long-standing discussions that very much, again, depend on your context. And so, like, if you're trying to protect the AI and understanding how the AI works is important. It's a whole big field in machine learning to try to interrogate a model, right? And you can do that, it's just a lot of work. Now, consider another situation where the AI has an output, and the output is independently useful, right? Maybe it's a design for a satellite or something of the sort. Do you need to interrogate the model? Not necessarily. You might want to, because if you understand why the model is predicting the satellite, you might be able to figure out what higher level feature is actually being used and not just this very specific design, right? So it might, in that case, it would be in your best interest in order to figure out what's going on. There is a big push for interpretable models, especially in the area of healthcare. If this is used for some sort of health output, what I've heard is that interpretable models are much preferred by agencies and even providers themselves, because they can, as a doctor, then you can follow along and understand why these outputs are occurring. In terms of Peter's suggestion about a repository for training data, I've thought about that in particular. That's come up a number of times in events that I've been at with Artie Rye from Duke Law School. And my sense, based on the input that I've heard around from the room, I'm not the expert here, but they hated that idea. They hated it, right? Because there's a lot of personal information there, and so they're worried about, confidential information, but it's also market value. Like training data is much, much, much more valuable than any patent value. They're like, we will never give you the access to this, pot of gold that we have. So in theory, the idea of training a training repository, in the US, we used to have like, you could give them your invention, right? You could actually give them your physical invention. It's interesting, but I think that you will have a large fight against that. If it becomes a requirement, you might say this is an alternative way to satisfy, the written description, enablement types of requirements. But I don't think you'll ever get to it being a requirement, at least.
I'm just thinking about that huge repository being hacked afterwards. That would be lovely, I think some states, the names of which I won't be mentioning now, would know what to focus on afterwards, right, as a hacking target. Maybe just as a footnote, I mean, we have been talking about product by process protection in Europe, and this is a way of protecting AI generated, or potentially protecting AI generated inventions that has been discussed quite a bit in the European literature. And I mean, correct me if I'm wrong, but I understand the consensus to be that this is probably not going to get us very far, just because even for a European broader product by process claim, you have to identify the thing that comes out at the end of the workbench. And if you protect, if you want to protect outcomes that a powerful AI machine generates, certain time down the road, you may not be able to identify that with sufficient precision. So I understand the consensus in academia, at least, to be that this may work sometimes, but not, on a very comprehensive level. One thing, but I think we can. We probably can't even discuss this anymore properly, and we can certainly not solve it. But even our learned discussion today about patent protection versus trade secret protection, and about can humans own patents on inventions generated by AI to a certain extent, has something of a binary character, because we take patent protection as it is, or we tend to take patent protection as it is, as a given, sort of, and then we only talk about who holds the patent or whether there is a patent at all. While there, basically patent is something created by legislation, so we might also be able to say we need some sort of patent protection, but we have to shape it in a different way when it comes to AI generated inventions, right? And the same may be true for copyright protection, for example. Authors' rights in a traditional sense. Doesn't an AI system need protection against libel, or does it have fundamental rights that could be infringed on by distorting copyrightable works that the system has generated? Probably not, right? So I think there's certain, we should also think about tailoring the basic types of IP rights we have to an AI IP frame or situation or context. And this may even get us farther than simply talking about only whether there is patent protection, yes or no, in a very binary and traditional fashion. But this, just as a thought, I see raised hands by Peter Thompson, Beat Weibel. I don't know who was first, so sort it out yourselves.
I think Beat was first.
Okay, Beat.
Okay, thank you, Peter. I just wanted to comment on this product per process. I mean, that only works if the process itself is, of course, patentable. So it only works once, so to speak. And in my example of the suspension, you only would be able to protect one type of suspension by this new process. So it's maybe a transitional crutch, but not the solution to the problem. But regarding your last question, Peter, I just want to, let's say, answer why I request an EU software register and flexible examination terms, because we have to be aware that by opening new technologies for patentability, which is, in my view, great, because technology, of course, develops, and that's also the intention of TRIPS, etc., that it is open to all technologies, to new technology, etc. We create more and more patents, and also in this ecosystem that I was talking about, we even create much more patents. Let's take, for example, 5G. Huawei is filing like hell because they want to have a big share as possible of the 5G SAP cake. And if we are now opening AI inventions, if AI systems start to sequence inventions, then we get even more patent applications. So therefore, we need a counterbalance. And my proposal is the following. All these, or let's say the majority of these patent applications, are not filed because they should be enforced in terms of the exclusivity right, but they are filed to protect or to document one's share in such an ecosystem. And why are we filing patents for that? Because we have no other means at the moment. We have no other IP right that would allow that. And there are two solutions that I proposed. One would be a kind of utility model or short-term patent, petty patent, which is not examined, which just gives you a grant, a right, an entitlement to document your contribution to a digital ecosystem for a certain short time, because it will be outdated anyway after a few years. So I mean, we don't really need a 20 years patent for that. And we don't need patents that take 3 years, 4 years to be granted for that. So we need a more flexible, more quick examination procedure for such IP rights. And the second one, the second solution could be this EU software register, because this could be a proof of authorship, ownership in software code, which is exactly what people are looking for if they file software patents for the majority of the cases. And today, this is just not in existence. So we have to rely, if there is a need to prove ownership in software code, we have to rely on the US system or the Chinese software register. And with all my respect for China, I rather prefer to do it in the US, or would even more prefer it to do in a domestic, let's call it domestic EU system, where I just could enter my source code, get ownership entitlement on all that stuff, and then I wouldn't have to do all this flood of patent applications that will be never enforced.
Glad to hear that you are in favor of both retailoring existing IP rights for an AI/IP context and in favor of registering copyrights. I think I could engage in a long debate now with my colleague Florent Touvenin on whether this is advisable or not, but we kind of discussed the topic at a recent IPI event, and he's fully aware of my position, and the IPI is as well. I'm also a fan of registering more in the IP area. So just my support for what you said. And we go on to Peter Thompson and then to Ryan Abbott, who also raised his hand. And then we have actually already to look at time, because it's 6:30 and we told people we would finally be done at 6:30. So maybe after Ryan Abbott, if there are any further very urgent remarks or questions, there would of course be room for that. Otherwise, we might conclude and postpone our discussion to the next event in September. Peter Thompson, please.
Yeah, thank you. Well, just the US deleted the statutory inventors' rights from the law on the AIA when the AIA came into force. That's just a side remark to Beat Weibel's ideas. Now, what I was a little alerted about, Peter, what you said was you gave the impression that there could be patent protection for unpredictable outcomes of an artificial intelligence system, so that you have a new generation of reach-through claims, I would call it. That you claim everything that a certain artificial intelligence system would create. And I don't think that we need another wave of reach-through claims in Europe. Maybe I misunderstood that.
Sorry, then I expressed myself badly. What I was trying to say was that there seems to be a consensus in the European discourse that reach-through claims do not provide protection for AI output, which you cannot sufficiently describe with sufficient precision at the kind of outset, whenever that outset is, right? So yeah. I'd be with you, and I think that's basically the right way of looking at things. Yes. So this shouldn't be our outlet for lack of protection, if we have any.
Okay, thank you.
Right. Yeah, sorry, Ryan, you're muted, sorry.
Right, what I just said was brilliant, but I'll do my best to repeat it. I'd just like to make a comment on the idea of a two-tiered system, which has some appeal, particularly, for example, in copyright term, but on the whole, I think we are better off with a technically neutral system that doesn't create a system like that. For example, if Siemens could take its engineering problems to an AI or a team of people to design a new car suspension, and it so happens that the AI does a better job of coming up with an innovative output, why should Siemens essentially be pushed into using a human team because they get IP protection or better IP protection? It seems really we ought to have a system that encourages innovation or new creative works, regardless of the source of it, to generate socially valuable outcome. And I think that happens best when we don't discriminate between AI and human behavior. Final thought from me.
Very good. Well, that seems to be a good final note. For me, are there any very urgent things you might just, speak up or be silent forever? No, just until September. Okay, so that leaves me with not the duty, but the pleasure to thank you all for what I think was an excellent event. I learned a lot. That was real fun. I hope you enjoyed it also a bit. Thanks to all the speakers and the audience for staying with us on a Friday afternoon for so long and so complex a topic. I think that was a great event. If you liked the event, then be with us for the next one in September. I just quickly look up the date. It's September 13th, again at 3 p.m. in the afternoon, and we will be looking a bit deeper into some technical and economic backgrounds of AI business models and related IP protection issues. So hope to see you there, and in between, enjoy a great summer, a corona-free summer, maybe even traveling. Very healthy in any way, and thanks for being with us here today. It was great, and thanks again to the IPI for supporting us on that. Have a good evening and an excellent weekend. Bye-bye.